Good morning, good morning, good morning, amazing Leonard. It's so good to see you. It's Wednesday. I still don't know what day of the week it is. It's July 22nd. I can't believe it. It has just zoom. I was talking to Travis yesterday about getting ready for all the things that are happening at the beginning of August. And he's like, yeah, it's like, I don't know, 10 days, 15 days. I'm like, it's all going to be fine. It's all going to be fine. So we have been very busy on the personal life side of things with getting ready for DCI finals in Indianapolis, getting to go travel to see Travis, getting ready for him to immediately move into college after DCI finals, and then also trying to be present and enjoy the moment and do all the things. So today we are catching up on Sarah Boone. I know that there are 10 million things going on in the law. We will catch up on some of those tomorrow, because today the state has responded. They responded at the beginning of July. We haven't had a chance to check on it yet, but Sarah Boone's appeal is one of those things that I looked at and went, this might be one of the worst appeals I think we've ever seen. And I'm curious to see how the state responds, because I remember a lot of my response when I went through it live with y'all was, what? No. Girl, no, what are we doing? No. And for those of you that are not up to date on Sarah Boone, I'll do a quick road so far, and then we will just look at the headings of her appeal before we go to the state's appeal. So if you're like, I remember it was bad, but I forgot why, don't worry. We'll do a quick road so far, and then we will get back to it. For all of you that I ran into on the road this trip, hello. It was so good to see you. Thank you for saying hi. To everyone whose spouses I ran into, hello. They were all lovely. Thank you for having them say hi. It was lovely. For everyone who saw me and I didn't get a chance to say hi, hello. It was lovely. For everyone in Texas, I don't know how you do it, but every time I travel to Texas is like, hey, girl, this isn't going to work for you. So we will tell some of those stories at the end of stream. So just remind me. So we're going to go through all the Sarah Boone stuff first. Everything will be timestamped below for y'all and for replay crew. And then we'll tell some quick little travel tales before. That was me. I have a tab open somewhere. Quick little travel tales at the end of stream. And then we will get into some more of that when we get to members only. We will get to members only soon, not this week, but we will have a members only before I travel for finals. And then I have some stuff to share with you guys in the app. I forget how much I am in the moment while traveling. And then I'm like, I have all this stuff I've been meaning to post and share. And then I'm like, but I didn't realize that when I was like, oh, we're going to Austin and San Antonio and Dallas, that I would spend quite a lot of my time in the car driving. And I'm a motion sick human, so driving does not mean I can also do phone things. I am just driving. So that. Barrett said, will there be a David update? There will be on the podcast. Let me answer that and then we'll roll the intro. I am not covering day by day of the preliminary hearing for the David case. Singer D4VD, David Burke. The preliminary hearings going on in Los Angeles, California. I can just tell you, here's how that's going to go. There is going to be a lot of evidence that is going to be really disturbing. And there will be some outlets that are going to lean in to the most horrific details of what is going to come out. Hopefully there will be some outlets that will just give you a little bit of a blow-by-blow of what's happening. I'm going to take the entire preliminary hearing and summarize it for you. At the end of the preliminary hearing, to the shock of no one, he will be held to answer. He will be held to answer probably on no bail. He'll be held to answer on no bail because it's a special circ murder case. What's going to happen after that? After he's held to answer, they will set pretrial dates. They will start to set trial dates. The district attorneys will take it to the special circumstance committee, the special circ committee, to decide if this is a case where they are seeking life without parole or if they are seeking just the death penalty. Yes, California does not implement the death penalty. There's a moratorium on it, but people are still sentenced to death row. So that is a possibility in this case. Now, vis-a-vis the Nick Reiner case, that's not even going to come back for preliminary hearing setting until September. But in the Nick Reiner case, I think there's a strong argument given that this was a family case. There seems to be significant indications of mental health, et cetera. I think when we are looking at a case like the Nick Reiner case with his family that was very much against the death penalty, that there are some stronger arguments that it is not a death case. But when you are looking at the torture killing essentially of a minor, you've got a kind of a different set of facts when you are looking at what the district attorney's office might do. So they may well decide that this is a DP case. They may not. But I will give you an overview of what the prelim is without getting into every single detail to say that there are things you can't unknow. There are things you can't unsee. It is worse than you can imagine. And I'm going to leave it at that. So it is a deeply, deeply disturbing case. So we will go over that on Monday after the preliminary hearing. Hopefully that's good. He Gives Beauty for Ashes isn't the David case a DP case? Not necessarily. They haven't decided yet. So the process at the district attorney's office is normally after preliminary hearing. And again, new bosses, things can change. But after preliminary hearing, they do a committee. The LA District Attorney's Office, and I don't know if other offices do that, but the LA District Attorney's Office allow the defense to also present information to them. Sometimes they invite the defense attorneys into that meeting. Sometimes they say, can you submit like a packet of information you think we should know? And they take all that into consideration when they have those conversations at the committee hearing. And it is not just decided by one attorney, it's a committee hearing. It's not just decided by the attorney that's prosecuting the case. All of the bosses are involved with that. Enchanted Wings, and I'm going to answer this question, then we'll roll the intro, because I think these are good questions. Enchanted Wings says, how does DP work in states with a moratorium against it? People are on death row, and if the governor changes or if things in the state change and they start implementing again, then it can be implemented again. But they are treated as if it could be implemented at any time, unless the state, and California has a really robust, to the chagrin of some, but they have a really robust process of changing the laws through voting. So you could see the voters say that they want the moratorium gone. You could see the voters say that we want it off the books. So there's options there, but right now it is essentially stayed, but it could be unstayed. And that can happen at any time. But if somebody is sentenced that way, then they get all the appeals that come with it. The process is a much longer process. There's more that the defense has to do. The trial process is different. It is a much more substantial process. So hopefully that helps. But no, it is, I say, I trust the law nerds to know themselves well and to trust the outlets you are looking for the amount of information you want to know about this case, because there are things you can't unknow. It is a deeply, deeply disturbing case. Deeply disturbing case. And it's really hard. So I will do an overview Monday and we will know that. Let's see. Robust means no. It means things can change. Without getting into all of the things in California, there are many that think that the way that California can amend the laws can just be kind of overrun by who has the most money. But there is a process for the voters to change the laws directly versus voting for legislatures. So it's different than some states where the voters can't directly pass a law. So it can happen. However, like all things in our politics, I think there are too much money and there is too much money involved. And they can get, the campaigns on the different propositions can get very confusing. The way that they're worded can get very confusing. We've seen propositions that are worded in like the negative. So you think you're voting no on a thing, but then the no implements the thing. So there's a lot of criticisms of that system. My criticisms of that system is that money can corrupt just about anything in politics. And so there's too much money in it. And I wish there was less money in it, because then I think people's voices could be heard. But that's my frustration with it, for sure. So HD Law Nerd Life, because we're answering questions and then rolling the intro. Any thoughts on the Lindsay Clancy case? Will you be covering it? The victims in that case, for those of you not familiar with it, are Lindsay Clancy's 3 children. It is a not guilty by reason of insanity or mental disease and defect. I don't remember the name of the law in Massachusetts. It's going to trial now. I am not covering it. Her kids are her victims. I am not covering. I do not cover that type of case. I am not covering that case. I am interested to see down the road how they do the NGI part. We have covered an NGI case with the Xzibit case. It is going to be a lot of doctors. It is going to be a lot of medical testimony. It is going to be a lot of difficult testimony. I am curious to see what the jury does, but I'm not covering it for trial, and I'm not covering it in and out. It's too much. It is too much. I don't want the details. I don't want to know. I hope that whatever doctors are testifying are easy to follow and that the jury understands what's being presented on both sides. So I'm not. It's incredibly sad. And especially when we are dealing with parent killing cases, I don't cover them. I have covered very few parent harm to children cases. I do not have a lot of a threshold for it. I do not have a lot of objectivity around it. I think that there is a lot of room to discuss criminal culpability and NGI. I don't always know if the context of a given case is the easiest way to have that discussion in a neutral way because the facts are so difficult. We looked at it in the Xzibit case about criminal culpability and mental health. In that case, it was mostly drug related, which is not pharmaceutical drug, but like illicit drug related. So we had that conversation a little bit more there. I think this case is going to be more nuanced than that when we get to the medical testimony. A number of you said not criminally culpable. Oh, we've talked about that before in Massachusetts. I really, really like it. I think not criminally culpable is a very good way to neutralize the language because I think NGI is really outdated. And I don't think it actually encompasses what the laws actually mean. I also think mental disease or defect is difficult, but not criminally culpable. We've talked about this in other jurisdictions. I like it a lot. I think it's really good languaging. And I think it's important as we evolve as humans, hopefully, that the language also evolves. So I think that I might look back at some of the testimony down the road on the criminal culpability part. I am not going through the facts of that case. So I appreciate your understanding. I appreciate you guys asking. I do not have the bandwidth to cover a trial particularly of that nature at the moment. So we are going to today cover Sarah Boone. I am not going to be covering trial, at least between now and my kid moving into college. There is a lot on my plate, and I don't feel like I can well show up for a trial at the moment. I just truly, truly don't have the bandwidth for it. So it's summer and there are lots of cases and we will be getting back to those cases, but it's going to be okay. That case is also one where I am mindful that there are a good percentage of law nerds who want to watch cases that I'm covering and that case is like a no. I'm also very mindful of like the FOMO. We cover hard cases. This one is a no for me. I would say that when we are getting into depending on how the trial is phased, if you are interested in that trial and you do not want to get into the facts of the case, it's okay to dip in when you get into the second phase, the culpability phase of it, because they're going to find, if they're doing it in two parts, and I don't know if they are, but if they're doing it in two parts, they will do did the person on trial do the thing? And then they will get into the second phase of, is the person who did the thing culpable or not? That part might be interesting for y'all to tune into and take a look at how that is done. I will keep an eye on when that is when that is happening, but I don't know if they're doing it in 2 phases or if she's going to plead to the first phase and just go to the second phase. So I think that it will be interesting. Sane said the only reason I wanted EDB's opinion was because MA's criteria for not criminally culpable are different from other states. It's Massachusetts. I'm not surprised. It's not a split trial. The judge denied the defense request. That's weird. I like your dog more. That's a fantastic screen name, by the way. That's weird. It's not a split trial. The judge denied the defense's request. That's odd. That's odd. Bifurcation is, well, Emily, it's Massachusetts. But that's odd to me. However, we have seen cases that have gone to trial only on the culpability phase or the not guilty by reason of fill in the reason. And you've seen people plead guilty to the first part and then just go to trial on the second part, which makes a lot of sense because the NGI or, and the reason I shortcut NGI is because it's such familiar phrasing, but the NGI essentially says, yes, I did the thing, but I'm not culpable for the thing. And so it makes sense if people say, yes, I did the thing, but I'm not culpable, and you just go to trial on the culpability. But Massachusetts does things differently, and I guess we will see. So with that, I am not covering trials at the moment. I am going to be giving an overview of the David case on Monday without all of the horrific details so we can overview it. I am going to be covering, I intend to be covering all the legal updates we have missed tomorrow. Today, we're talking Sarah Boone. We're talking Sarah Boone. That's what we're doing. So today, Sarah Boone. Tomorrow we might be back in Massachusetts, depending on everything else that's going on. We should roll the intro. We've done a lot of overviews, which is fantastic. Also, Emily, how is your heart? Very full. My heart is very full. I got to see a number of DCI shows that I hadn't seen yet this year. We did not get rained on at the DCI Dallas show, which was delightful. Though the humidity was 100 out of 100, we did not actually get physically rained on. I got to spend some time with my kiddo. I got to see him perform multiple times, which was lovely. I got to spend time with friends that are with the DCI organization, with Flow Marching, with the incredible core that is the Cavaliers. I finally got to see the Blue Devils show live. I really enjoyed it. I have not seen the Blue Coats show live. Emily, how bold will we be with copyright today? I might show you my favorite Blue Coats situation at the end of stream. Remind me, because it stole my heart. And I know it's easy to just be a Blue Coats hater. I know, I get it. Lots of people do. Whenever cores rise to the top, people just want to be haters. I get it. I'm an enthusiast. Really enjoyed seeing Vanguard's show live. It was really a lot of fun. Love seeing the things that Boston is doing, circa like Cirque du Soleil. It's fascinating. Every show, I think, has one moment where somebody's getting like lifted into the air. And I'm just like, why? Every show, somebody's just getting hoisted into the air. I love seeing cores have those little moments that you look at them and you're like, oh my God, that's just so them. I also love a show that unfolds that people who are deep nerds of core are fans of, but also a casual watcher is like, I enjoyed the music. I enjoyed the vibes. That was really fun. I love a show that can do both. I think that Blue Devils have done that really well this year. Of course, I think the Cavaliers have done that really well this year. I think there are some shows that are just so much fun. Bentley, I think this is where we're getting. Bentley said, as a former cheerleader, why not throw someone in the air? I think that's what's going to happen next year. I think unless there's rules, we're getting basket tosses next year. I really do. I think we're getting just like, I think we're going to get like a screamer trumpet just like yeeted at some point. I think it's what's happening next. I do. I think it's what's happening next. All right. Let's see. Sub Rosa said, oh no, this one time at band camp. Yes, we started. The chat started it this time. Sub Rosa talked to the chat. Chat started it. I'm teasing. Well, not really. Chat kind of started it. Don't worry, we'll get to the rest. So, RK said, was it the Blue Devils who had their bus catch fire? I don't remember which corps had a tire fire, but literal tire fire. Tony, Crown was eating people in 2001. That sounds about right. I wonder, I feel like late 90s, early 2000 corps had less lawyers involved. So the yeeting might have changed. Some of you will notice that the Cavaliers have somebody on a one wheel with a flag, and that individual's now wearing a helmet. Rules. The adults were just like, no, you can't do that. So it's fun. And I'm like, but the rifles and the sabers are more dangerous than a one wheel, but all right. Adults and lawyers, and lawyers. James said yes, the 2000s were a lawless time for corps. Yeah, my friends marched in the 90s. So when my kid's like, I'm doing corps, I'm like, I have memories. Though there's a lot of rules in place. James said there's a reason I don't play the flute. There is a lot of flute in whose show has a lot of flute this year. I do not remember what show it is. Lots of flute. All right. Are we ready? It was the Blue Devils bus that caught fire. Well, which sucks for all the performers who lost all of their stuff. However, for the performers who lost all of their stuff, I did see that they had a huge fundraiser and lots of support. And all they need to do is be like, hey, we just need 10 pairs of black shorts, 10 tank tops, and a lot of sunscreen and some black socks, and it's going to be fine. At least it's easy to repack. The Blue Knights, thank you. A lot of flute. It's lovely, but a lot of a flute solo. I love all the bass drums are killing it this year. I love Cavaliers perk. Emily loves a drum line. You're shocked. All of you are shocked. No one is shocked. So, are we ready? All right. Let's get to getting. Don't forget the underwear. They do. They need undergarments. Things that are easily washable. Why are there 100 teams named Blue? I have no idea, but there are, let's see, the Blue Coats, the Blue Devils, the Blue Knights, the Blue Stars, and I feel like I'm missing one. But there's 4 or 5 that start with blue. I don't know. It makes the Cavaliers stand out though. So it's great. Paralegal for the People said finally made it to Buc-ee's and got some shorts. I love it. I will share some pictures on members only. The Cavaliers made it to Buc-ee's, but it's my favorite time of season when they do Texas tour. And when they do Texas tour, all the corps stop at different Buc-ee's. I love the pictures. I love the international marchers, especially the ones who have not been touring the States before. The international crew at a Texas Buc-ee's is a delight. Absolutely a delight, and I love it. A delight. I love seeing it. All right. You remember? We ready? We ready to go? All right. Let's roll the intro. Let's talk Sarah Boone, shall we? Emily, we just want to crash out on the wildness of this appeal? Yeah, we do. Because why not? It's one of the worst written appeals I've ever read. So it's a Wednesday. Let's jump into it. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Beginner Crafter asks in the chat, are there bans from outside the US? There are marching, yes, because I know that there are Canadian DCI groups, but there are marchers that are international that come and march with different corps. So there are a large group of marchers from Team Japan that march with a bunch of different corps. There are marchers from all over the European countries. So I have met marchers from a number of different countries just with the Cavaliers, but corps have members from international that come to the US and march. There are some Australian marchers. So yes, there are marchers that are international that join corps in the US. And I think that the ability to send a tryout video and stuff have made it so much easier for those members. Though I met I think 17-year-old, might have been a 16-year-old last year on the Cavaliers from Team Japan. And I'm like, I stressed out about sending my kid from here to Michigan. I can't imagine being like, bye. I'm sending you to the States. Have a great tour. I will see you in 3.5 months. Like, I can't imagine the parent stress. I can't imagine the parent stress on that. But also, they're taken such good care of. Like, there is so much care given to taking care of the marchers. And I think a lot of that has to do with the fact that those in leadership marched in like the 80s, 90s, and 2000s. And so they're like, hey, we can do this better. And I love the attitude of, hey, we can take care of these marchers well, versus the, well, back in my day, we did this, and so y'all can suck it up. I love the hey, how can we serve these humans better so that they have a great marching experience, and so that they're well taken care of, so that they're healthy mentally and physically, so that they don't, have skin cancer in 20 years, and so they have a good time. And that matters a lot as a parent. All right. Sarah Boone. For those of you that need a quick road so far, I actually took a look back at this when I was prepping stream, and Sarah Boone was convicted in October 2024. How has it been that long? Y'all, how has it been that long? I don't know, but it's been that long. So Sarah Boone convicted back in October 2024, sentenced in the very, very end of 2024, December 2024. Y'all remember this sentencing because Sarah Boone was like, I forgive all of you for the things that you have done to me. Because Sarah Boone views herself as a victim. I do not agree with Sarah Boone's perception on that. You might have heard of this case because there was a period of time, brief though it was, that Sarah Boone was representing herself because she went through like 9 different lawyers. She was convicted for second-degree murder in Florida for zipping her boyfriend into a suitcase and leaving him there. Second degree is the indifferent to what happened. Some of us were looking at this case going, could have been a first. Could have been a first. However, a second degree still has the option of life. Remember, Florida does not have parole, so life is life, period. So on a second degree murder, Sarah Boone got life, period. So after that, Sarah Boone got appointed a counsel for appeal. And with counsel for appeal, she went through multiple counsels for appeal. One of them was like, I'm not doing appeals anymore. One of them were like, I actually am becoming a prosecutor. I don't do appeals anymore. There were so many different appellate attorneys. And then there were numerous, obviously, motions to continue appeal. Her appellate brief did not get filed till April 2026. She was sentenced in December of 2024. So there were times where I really understood her frustration that she just kept getting bounced appellate lawyer to appellate lawyer to appellate lawyer. I understand that. However, the system is looking at that being like, you've got time. Like, there is nothing here that is so urgent that we need to be so urgent. Also, my understanding for Sarah Boone is deeply undercut by the fact that in trial, during the prosecution's rebuttal, we saw quite a few body cam videos of Sarah Boone, and she's a challenging human to have a lot of empathy for, because her behavior is her behavior speaks real loud. So she finally filed her appeal after her wild sentencing, where she literally ripped into everyone in the system, from the judge, who I thought was great in her case, to every single attorney that worked in her case, to the victim, to the victim's family, to everyone. She's a challenge. And then her appeal read like someone was trying to meet a word minimum on a freshman essay. It was wild. Rory, I hope I pronounced that right. Rory, I hope I did. Said EDB, hope this isn't a silly question. It's not. That's why I pulled it up immediately. Why is there a first degree and a second degree if there's no different in the sentence? In the Florida law, as we went through it during this case, there is different options in first degree and second degree. So second degree can be life, but it doesn't have to be. There's options for determinate sentencing on a second degree, so the judge gets to make that choice. The first degree, the sentencings are more fixed, and there is less choice for the judge. The judge could have sentenced her to a non-life sentence. So the judge could have sentenced her to a determinate amount of years. The prosecution at one point asked her if she wanted, like, I think it was 15 on a plea deal. And she was like, no, we're rolling the dice. So she got the opportunity to have a determinate sentencing. So I think that's a great question. And it's because there's options there. It's like when we're looking at Utah and we're seeing the aggravated murder or the special circ murder, then it's a choice between DP and life without parole. But once the DP is off the table in Utah, it shifts back down again to life without parole to a determinate, like 25 to life sentencing scheme. So it shifts the judge's options. And in Boone, the judge did have options to sentence her to less than life. Now, he didn't exercise those options. What they often say after trial is that if the judge is sentencing you after trial, they know a lot more about you. And sometimes that doesn't go well for you. Sarah Boone was one of those cases. Through Sarah's choices, and I say Sarah's choices, not her lawyer's choices, because some of these choices she was insistent upon, including pursuing a battered spouse defense that did not fit the facts of this case appropriately. In pursuing that defense, the judge became aware and the jury became aware and all of us became aware of much more information about Sarah Boone's own behavior in her relationship with the victim that I think undermined her defense. And we saw that in recordings she had made and body cam footage that the prosecution used as rebuttal. None of that would have come in if she had not pursued that defense. And the reason we're taking a minute to talk about it is because that's part of what Sarah Boone used at appeal, or her lawyers used at appeal. She was insistent on running that. She saw herself as the victim. Those videos were videos of someone abusing their victim, Sarah Boone being the one abusing her victim. It does not undermine the fact that there had been times where her murder victim, her boyfriend, had been violent against her, but it definitely shifts the power dynamic in the relationship and whether or not this was a defense where battered spouse applies. I think that it does not apply to her, but she can't see it that way because she was the one who was used to being in control, because the power dynamic in that relationship rested most often with her, not with her victim. And we saw that throughout the prosecution's rebuttal in this case, where she would essentially hold her victim hostage by taking away his identification and all of it, not taking him to work, etc. So we learned a lot in that case. And we continue to learn a lot about Sarah Boone in her prolific writing from custody. So we're going to take a look real quick at the opening brief. We're not going to reread it again because I don't have the patience for this shit again. We've already done it. We will link it below. We're going to look at the headers to kind of refresh what the arguments are. Then we're going to fly to Florida and see what the state had to say, because some bold arguments made here. Hopefully that gives us enough of a overview, but I was not prepared for the videos that came in during the rebuttal. And the reason I was not prepared for them is because when I look at cases, I really have a hard time not filtering them through lawyer lens. Like, if you know about this, why would you open the door for this? But Sarah Boone was very insistent in her defense. And I think her lawyer, to his credit, worked well at communicating with her and saying, okay, if this is what you want to do, this is what you're doing. But I had a hard time if the defense knew all of this, how do you even open that up for the jury to see it? Because it just eliminates all doubt about what Sarah's role was in this relationship with George Torres. And it was heartbreaking to watch, just heartbreaking to watch. So, and it sticks. Those videos are the type of thing that will stick with you. And there are some things in criminal cases you can't unknow or unsee. And I am sorry that all of you will just not be able to unsee some of those. It was really, really sad to watch. So let's take a look real quick at the overview of the defense arguments on appeal. Generally, I think, and I am correct. Emily, always? No, definitely not always. But in this, I am correct, and I will not be swayed. But in appeals, I think that you should always start with your strongest argument and work from there. Your reader will be looking at your strongest argument, and it will shift the lens that they read the rest of your arguments through. You start with your strongest argument. So when appeals start with an argument, and I'm like, that's all you got? It's hard to look for other strong arguments. In anything that you are doing, you start with your strongest argument. I don't care what you're doing. You know, you're a day late on your return to Amazon and you need a little bit of help. Start with your strongest argument. That's it. We'll talk about the Shirley case later. We talked about it on the podcast last week. Talk about it later. Amazon's more forgiving of a day late than the Supreme Court is because, you know, not lawyers. So let's take a look at my desktop. Sure. Even my camera is just like, wait, are we back today? Yes, we're back today. We can't just run away and talk about drum lines as much as I would love to. Look, it's a sound bath. And if you guys are going to any different shows this year, if you want to make some time to be in the lot, if you can, and go see the different corps warming up, you can just stand there and watch. Doesn't matter what corps it is. Have fun. Just go explore. Wear bug spray, sunscreen, take water. It's going to be great. All right. Here are our table of contents. Love an appellate brief. Love being able to just tick through it real quick. Here's where we're at. The trial court erred in improperly limiting the appellant's opening statements regarding the overt act requirement. Remember, the defense was arguing that the court limited their opening statements, and all of you are going to say, but Emily, opening statements are not evidence. Correct. They're not. Opening statements are not evidence. The trial court did not provide an adequate remedy to the appellant for the appellee's substantial discovery violation. The court did a whole voir dire of the witness that they're talking about here, and they said it wasn't enough. Sure. Erroneous jury instructions were provided on the, quote, initial aggressor exception for the self-defense rule. The trial court improperly allowed the admission of the appellee's expert opinion on an ultimate issue of fact. This is regarding the self-defense via kind of battered spouse defense. It goes into this was a justified homicide because she was in fear for her life. And the way that a kind of a battered defense comes into that is by showing that, okay, let's back up just real quick. Let's back up with real quick. I'm going to save a couple great questions because you guys have great questions because the law nerds are so smart. Let me back up just real quick as we're talking about this defense because it's going to come up in this appeal. But what the battered spouse defense is taking the self-defense and shifting it a little bit. In self-defense, you generally look at an objectively reasonable standard. And when you add in the lens of somebody's history with the victim, their history with abuse and with PTSD and cycle of violence, it's letting the jury say, okay, we're not looking at like a reasonable person. Would anyone in this situation act this way? We are shifting the lens a little bit to say, would somebody with this experience and background have responded to the situation? Would they have perceived, with all of this background, would they have perceived themselves to be in danger? So it shifts the lens that the jury is allowed to look through, and they do that through medical professionals. Now, the jury doesn't have to agree that that lens is the proper lens to look at it through. And so the offer is there to the jury to say, is this person acting out of fear that maybe someone else in a different situation wouldn't perceive the fear, but because of all of their background and because of what they've been through, their response is based on history. And the law allows that to be considered. In this case, though, you have videos of Sarah Boone mocking him while he's begging for his life. So this doesn't really seem like a circumstance where she is terrified of him. So she seems gleeful a little bit. And that is something that the jury is not going to be able to put aside. And neither could I. And I think neither could a lot of you. It's it's pretty clear to me. So those are the arguments here. But they start with the arguments that the opening statements were improper. Okay. Sure. Tell me how. So let's fly to Florida and let's see what the state has to say. Because I said throughout this reading, I'm curious to see what the state says. It's not for me to clap back at the appeal. My issue was with the writing of it. It didn't follow your traditional like issue, rule, analysis, conclusion, or analysis / argument and conclusion. It didn't follow the flow of legal writing. It jumped around, and then some of the arguments were challenging. And also you started with like the least legal one, like opening. Really? Real opening's your strongest argument? What are we doing? Hate it. Let's fly to Florida, shall we? All right. Bring a fan. Bring a personal fan. It's going to be hot. We're going to Florida. So now that we have a background, we are going to look at the state's reply. I downloaded this for y'all. I did not go through any of this. I am just now seeing that it is 45 pages long. Cool. Why is it 45 pages? I don't know. I have not read it. I have not been through it. Thank you for no spoilers. Great. Cool. 45 pages long. Let's see what the state has to say. Also, look, I dig the font. Emily, are we going to do an appellate font review of every jurisdiction? Yes. Because appropriate formatting matters, and which font your appellate courts and Supreme Courts use are of deep fascination to me. I love it. This one's vibey. I'm here for it. Now, the font I am assuming that this is the proper formatting. And yes, there are formatting rules for briefs in every jurisdiction. This is part of the local rules. Yes, you don't get to just pick the font because you feel like it's sassy. Each of them have their own. This is the opening brief from Sarah Boone's attorney. It does not seem to be formatted properly. I might have to start pulling the local rules when we look at appeals. and just tell you what the local rules are for the formatting and then let us decide if it's not formatted properly. Emily, does it matter that much? Yes. Look, appellate work is great work for those of you that are like, hey, things are kind of black and white and there's no gray zone, because the appellate courts work that way. The gray zone is for your argument, but the formatting rules are definitive, and the courts of appeals are sticklers for their rules. All of you are asking for a tier list. We'll work on it. We'll work on it. That would be really fun. But yeah, it matters. All of the rules tell you how to format them. And also, most of the softwares that you use to format these and submit them have it auto-populated. Like it's in the software. Like it just does it. Lindsay says, I can still hear EDB screaming about 45-line paper in the Washington portion of the Tati case 6 years ago. I was talking to another lawyer because we find one another whenever we are, but I was talking to another attorney at a Cavaliers show. We were in the lot afterwards, and we were chatting about all kinds of things, and formatting came up, and I was like, yeah. And then some of these lawyers are just out here rolling like a 45-line paper. And he's like, who even does that? I'm like, we're going to be friends forever. We're going to be friends forever because, of course, who even does that? It's awful. There's rules. I like the rules. Emily, shocking. Yes, if the rules make sense, I'm here. The formatting makes sense. They want everything to look the same. In the District Court of Appeal of Florida, 6th District, Sarah Boone Appellant versus State of Florida Appellee. I will try to switch when they say appellant to just Boone and Appellee Florida. So or prosecution, I will try to move us out of the appellant appellee language. But those are the parties on appeal from the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida. We've got the name of the Attorney General, the attorneys who are dealing with the appeal, the case number, the date, July 1st. Let's look at the table of contents. Table of citations, which is great. They put all the case law first. It's fantastic. Statement of the case and facts, summary of the argument. 1, the trial court did not abuse its discretion in limiting Appellant Boone's opening statement when it precluded appellant from using demonstrative aids. Right. They never said you can't, and it's not argument in opening. It's an overview of what the evidence will show. The court never said you can't say what the evidence will show, but you can't show inflammatory demonstratives that are videos that might not come into evidence. There's nothing wrong with that. It happens all the time. It's fine. 2, this issue is unpreserved for appellate review. Uh-oh. Oh no. Wait, what's number 2? We're going to flip back to Emily, you're flipping between the briefs. Yeah, but the font's different on both, so it's real easy to tell. Trial 2, or number 2, is that the trial court did not provide an adequate remedy for the discovery violation. That was regarding the expert as well, to the best of my memory. And the state is saying that that's not preserved for appeal. Remember, use it or lose it. Number 3, the trial court did not abuse its discretion by instructing the jury on the initial aggressor exception to self-defense. Yeah, if you started it, you can't turn around and use self-defense. Whom started it? Who is the initial aggressor? Right. We're trying not to have like loopholes. And then number 4, the trial court did not abuse its discretion in allowing Dr. Werner to testify about her opinion, and then conclusion and the rest. Okay, let's take a look. So they've got their table of citations. I'm starting to realize that now I might have to start running people's citations on my own, but are we starting that today? No, we're going to start that in the future because it's getting to the point where I have concerns about some of the citations we've seen in some of the cases. All right. Gloriously double-spaced, easy to read font. We ready to go? All right, let's go. Cheers. We have coffee. We have water. We're ready to go. The state generally accepts Boone's statement of the case and facts, but would note the following facts in support of its answer brief. So they are essentially pulling in the statement of the case from Boone. Let's look at the statement of the case from Boone real quick. Emily, are we flipping back to the preliminary statement of the case? Yeah, we're flipping back to the statement of the case. Also, the format of this, I think, is incorrect because but I don't know. I have questions. I'm not a Florida appellate counsel. Emily, did you ever do a lot of appellate work? No, I didn't do a lot of appellate work. It's a lot of writing, not a lot of talking. Does that seem like a vibe? No, I want to be in court. Statement of the case. We are now looking, for those of you listening in the background and can't see the marked distinction in font, we are looking at Sarah Boone's statement of the case because the state has essentially incorporated it. And we haven't covered this in like a minute, so we're hopping back in. Quote, this case commenced with an information being filed against Sarah Boone on March 23rd, 2020, charging her with second-degree murder, which allegedly occurred on February 23rd, 2020 in Orange County. The incident giving rise to the information occurred on February 24th, 2020, when the appellant and the victim, her boyfriend, were sharing a bottle of wine and decided to play, quote, hide and seek, wherein the appellant, Boone, had gone upstairs in their apartment to hide. Again, I don't think that's what we saw at trial, but this is her side of the story. They're going with her side of the story. After the victim did not come to look for her, Boone reportedly went back downstairs to discover the victim zipped in a suitcase, and both parties were laughing as she finished zipping up the suitcase, and the victim purportedly was able to stick a few of his fingers outside the suitcase as it was not zipped all the way. Sarah Boone then went back upstairs in their apartment and fell asleep under the assumption that the victim could get himself out of the suitcase. There are some facts left out of there, but the next morning she woke up and did not see the victim until she went back downstairs to discover the victim had died in the suitcase, at which point she called her ex-husband, who in turn directed her to call 911. A search of Boone's cell phone revealed 2 video recordings wherein the victim had exclaimed that he could not breathe, and Boone replied, yeah, that's what you do when you choke me, and that's what I feel like when you cheat on me. There are some facts left out of that. They're narrowing down those facts. According to the arrest affidavit, I don't know why they're bringing up the arrest affidavit in an appeal after trial. Just bring up the facts from the trial and cite to the transcript. I'm annoyed all over again. I am annoyed anew. According to the arrest affidavit for the appellant, the victim's autopsy revealed he had various injuries, and after investigating, detectives showed the video recordings to Boone, with her denying any recollection of the videos. I believe that part. I believe alcohol wiped that memory well away. And I think that when she was sitting in that police interview, it's the first time they showed him to her, and she went, like, internally, fuck. Because I agree. I don't think she remembered those at all. But also in an appeals, especially when this appeal is based on the trial, go to the trial transcripts. Why are you going back to the affidavit? Just go to the testimony at trial. What are we doing? She was arrested after the information was filed, and during the first few years of the case, the trial judge entered an order on June 28th, 2024, highlighting Boone's extreme difficulties with retaining defense counsels. The order revealed that Boone had gone through 8 different counsels, and all counsels had moved to withdraw due to general irreconcilable differences with Sarah Boone. Finding that Boone was no longer entitled to counsel, The trial court found that she had, quote, forfeited the right to counsel and that her conduct forced her to proceed with the case pro se. I take issue in that the court did say she could hire her own attorney. The court said essentially, we are not appointing attorneys to you to just be abused. Like they're not indentured. Like you have to work with your attorney. And if you can't work with the attorneys, then we're not going to keep paying to appoint new attorneys. Because every time a new attorney comes in, they have to review the entirety of the case. And the more years this has gone on, the more there is for them to get up to speed on. So we are now paying attorneys, and not all attorneys stayed on the case to review it and start working with her. Some bounced almost immediately. But how much are you paying attorneys to review the case, have one conversation with her and be like, deuces? And how many of those attorneys, my speculation, how many of those attorneys, I wonder, said, I have reviewed all the discovery. I have reviewed the videos that the state is going to use. If you try to run this defense, it is not going to work. This defense is not your best bet. Your best bet is to reduce the charges and take a plea. And Sarah Boone kept saying, but I didn't do this intentionally. And I imagine, this is all my speculation, this is lawyer brain speculation, and I imagine that the attorneys said second degree means not intentionally. So y'all agree, but you were indifferent to whether he died or not, and he was telling you that he couldn't breathe, and you didn't give a fuck, and then you went to bed. That's a second. So we all agree that this is a second. Great. You can still get life on a second. You need to do something to not get life in prison. And after the judge, my speculation, after the judge sees the video of you mocking your victim, and then if the judge sees the body cam videos, and then if the judge sees the other videos of you abusing the victim in this case and mocking the victim in this case, the judge is going to be like, nah, we're done. So your best bet is not this defense. And I imagine that Sarah Boone went, you don't understand. You're against me. And I know better. And I am a victim. And you don't believe in me. And then the attorney was like, well, we can't even come to the understanding of how to run this defense. And I can't work with that. So away we go. So then the court, quote, forced her to proceed with the case representing herself. She was able to obtain new counsel. She had put out an ad in the public filings, and James Owen parachuted into the case and entered his appearance on her behalf on August 30th, 2024. They offered her like 15 or 20. They did. They offered her a pretty significant plea deal. She didn't want it. It was an error in judgment. Trial began October 14th, 2024. Boone's trial counsel had asked for a motion in limine to prevent, the state had asked for a motion in limine to prevent the defense from positing a battered spouse syndrome defense theory. The trial judge issued a mixed ruling on the motion. There were some notice issues with this. The court erred in favor of the defense on this and said, state, you're going to sort it out. Just sort it out. Sort it out. While the court would not completely exclude the defense, the court did rule that the defense would need to lay the proper predicate before the defense expert would be allowed to address the battered spouse syndrome theory. Predicate is common when asserting any type of affirmative defense. You have to meet the threshold before you can just throw it out there. We've seen this in case after case. The defense goes on to argue in their appeal that as it relates to the motion in limine on battered spouse syndrome, the state's trial counsel referenced statements where Boone ostensibly made to the expert witness who would testify at trial that led the state to argue that there was no, quote, overt act that would allow the defense theory to come in. Overt act being, what is the thing that Jorge Torres did that then triggered a response from Boone? What was the thing? Recognizing, quote, the risk of error with its request, the state's trial counsel asserted that the impaneled jury should not hear, quote, any prior instances of violence unless and until there is testimony that is self-defense that's recognized under Florida's law, a decision between defense counsel and the court, or discussion, between defense counsel and the court then ensued about the defense's experts' deposition previously taken and what her opinion would be. And so then they get into the facts on that. They said the trial judge inquired as to what the overt act would be that would give rise to Boone's self-defense theory. And the defense counsel responded that he was being put, quote, in the position now to disclose what our view of the overt act is. Correct. We're at trial. Now's the time to say, we see the case this way. What is the overt act? What is the thing that George Torres did that was so terrifying that Sarah Boone said, I am in fear for my life, and my only option is to go upstairs and go to sleep? Because people who are terrified go to sleep. I mean, she didn't get the keys to her car and leave. She didn't call her ex-husband and say, I am in danger. She didn't call the police and say, get here, take him away, I'm in danger. She didn't drive to the police station. She didn't do any of those things. So I think the defense was probably struggling to figure out what the overt act was going to be, because I think that they were struggling to figure out what the overt act was going to be because he was incapacitated in a suitcase. So, but the defense argument was, you're making us disclose our defense to the state in advance. So they go on to say that the trial court denied Boone's renewed motion for a statement of particulars, which is asking the state to go into more detail about what they're charging Boone with. This was a silly argument. The defense says after dealing with a number of motions, the trial court conducted a Richardson hearing on a number of late disclosures that the defense objected to, and the trial judge found that any discovery violations by the state were inadvertent. After the jury was impaneled and before trial on the matter began, the appellee's trial counsel, so the state trial counsel, indicated to the court that there was an issue with Sarah attempting to use demonstrative aids during opening statements. Trial counsel referenced the court's initial ruling on the overt act issue to argue that certain photos of prior injuries to Boone, in parentheses, ostensibly from the victim, just pull the transcripts and say what it is. Why are we making argument? Isn't this in the transcripts? Pull the transcripts. What in the world? The defense would have argued that the injuries that Sarah Boone wanted to show were injuries caused to her by the victim. That would have been her argument. Why are we putting it in parentheses, ostensibly from the victim? Pull the transcripts and quote the trial transcript. There's not enough coffee. They also said that they wanted to use boards outlining the laws on jury instructions. That's for argument, not opening. So they wanted to argue what the jury instructions would be in opening. Also, the jury instructions aren't set in opening. So you can't say the evidence will show that this is the jury instruction because we're not even there yet. They go on to say that the state's trial counsel referenced the court's initial ruling on the overt act issue to argue that certain photos of prior injuries shouldn't be shown. Then, after the court reviewed the proposed photos, the court agreed with the state and prohibited the defense from using those aids during opening statements. The aids that we normally see during opening statements are things like timeline, stuff that you need an overview of. Your opening statement should be showing the jury kind of when we use the puzzle analogy, like showing the jury what the front of the box looks like for the puzzle. Like, this is the puzzle we're trying to get you to complete. And you're going to get all these different pieces, but here's an overview of what those pieces look like when they're put together. That's what opening is for. They go on to say that the evidentiary portion of the trial began October 18th, 2023. I thought it was 2024. Did they just typo the date midway through their motion? Yes, they did. A few paragraphs up, they say trial on the matter began October 14th, 2024. And then down here, they fully fucking typo it. Add it to my list of criticisms. They fully typo it to 2023. They say the evidentiary portion of the trial on the matter began October 18th, 2023. They mean 2024. With several witnesses called by the state. Trial thereafter continued for several days with numerous witnesses and publication of various video evidence, including portions of video taken from Boone's phone, as well as the detective interviews with Boone before the state rested. See generally the trial transcript. After the judge denied Boone's motion for judgment of acquittal, remember this is what happens at the end of the state's case. It is called different things in different jurisdictions, but it is a motion to say that the state has not proved their case legally. It is legally insufficient, not just a difference of opinion, not just, oh, the jury could see this different ways, but there is a fatal flaw in this case and it cannot go forward to a jury consideration. It is called in Florida, motion for judgment of acquittal. Different things in different jurisdictions. And then that was denied. Sarah Boone started her case. Sarah Boone testified. She testified about the incident in question, what led up to the victim's death, her fears of the victim as he was attempting to get out of the suitcase that he was zipped in based on prior acts of violence against her, they say in parentheses, and the aftermath after she discovered he was deceased. Several additional witnesses testified for Boone. Boone rested her case. The state presented rebuttal testimony, including from Dr. Werner and others. While testifying about her 2.5-hour evaluation of Boone, Dr. Werner opined that Boone was not suffering from any PTSD that could lead to a battered spouse syndrome, and counsel objected. I don't remember that testimony well enough. I'm interested to see what the state says on this. I remember her saying, I remember the doctor testifying that she did not have any of the PTSD. She didn't have any indications of PTSD. And I'm interested to see the argument on ultimate issue, because a doctor can't say, well, she has no PTSD, therefore there's no defense. This defense can't make sense. But you can say there's no PTSD. I don't think she was in fear at this time, right? Okay. So they object, they say. A very lengthy discussion ensued between counsel and the court on the defense's claim of a discovery violation, pointing out that Dr. Werner had previously claimed during deposition that she had a different opinion and diagnosis. The trial judge acknowledged the different opinion rendered at trial. In response to the alleged discovery violation, the court decided to conduct a Richardson hearing. And after considering argument, the judge decided to allow Boone to conduct an in-camera deposition. So there was then a voir dire outside the presence of the jury. During questioning from Boone's counsel, Dr. Werner claimed that she had not previously disclosed her opinion on Boone during the initial deposition because Boone's counsel didn't specifically ask her about that. So her statement was, I wasn't asked. I wasn't asked. So I didn't give that information because I wasn't asked. After Boone's attorney's questioning concluded, the trial judge observed, this is your opportunity and your only opportunity to cure any prejudice. So the court was indicating to the defense counsel, do you want to ask any more questions? This is it. Ask any more questions. In response, Boone's counsel protested that he was forced to take a deposition, quote, on the fly. Welcome to trial work. And he was put in a very difficult situation, but the judge again reiterated that he was giving Boone's counsel the opportunity to cure the discovery issue. Again, the next sentence is again and later in the courtroom deposition. I'm reading that verbatim. Huh? Look, man, I am not the greatest writer in the world. I am not saying that I am. And you know what? You know what I do to cure that? I just keep it simple. And then I spell check. And then I check for errors. And then I make sure the dates are right. Just keep it simple. Just keep the sentences simple. Simple is better. Just literally the KISS methodology. Just some people are great at more descriptive writing, but just keep it simple. Again and later in the courtroom deposition, it wasn't a deposition. It was a in-camera hearing in Florida or a voir dire, but either way, not a deposition. Again and later in the courtroom deposition, I'm only keep moving or we're going to crash out on this sentence forever. It's wrong on so many levels. It's wrong. The state's expert revealed that her opinion had changed from the time of the initial deposition to the day of the trial. I don't think that's true. I think her opinion was more fulsome. After the state's rebuttal and publication of numerous videos, audios, and other evidence, the parties in the court began discussing jury instructions, and then they get into the jury instructions that they disagree with. Again, if the jury instructions are an issue, lead with that. It is one of the things that appellate courts resonate with. If something is wrong in the jury instructions, that can be a thing that will overturn a case. Getting the jury instructions wrong is a problem. All right. Are we ready? That was the defense's kind of overview of the facts. The state says we largely accept that overview of the facts, but we would like to add a few things. I hope that refreshing what the defense said is helpful, just because it's been so long since we have covered Boone's appeal. Hopefully that was helpful. All right. So let's, do we need more lip gloss for that? We do. We do need more lip gloss for this, because it's just, we got to get into the state. So let's get into the state. I have not read this yet, as evidenced by me being shocked that it's 45 pages long. However, there's no one I'd rather read it with than you. So let's take a look. All right. The state generally accepts Boone's statement of the case and facts, but would note the following facts in support of its answer brief. Boone was charged with the second-degree murder of Jorge Torres, or George Torres. I think they went with George. I've Californified the pronunciation. I think they went with George. The state filed a combined motion to strike the notice of intent to rely on the defenses of battered spouse. I read that awkwardly. Let me just start that again so it's not confusing. The state filed a combined motion to strike the notice of intent to rely on the defense of battered spouse syndrome, footnote 1, motion in limine, and motion for examination by a state expert. Footnote 1 says it does not appear that the notice of intent to rely on the defense of battered spouse syndrome was included in the record on appeal. Remember, the appellate lawyers are looking at just what is in the appellate record: the court file, the motions, the trial transcript. So when the appellate attorney, and this is not the attorney that did the trial, when the appellate attorney is looking at it, the appellate attorney is saying, I don't see the defense's filing. And remember, that was an issue when the state was saying, hey, no notice was filed. And the court was like, you're going to have to kind of roll with it. You're aware. This is the going off of the best of my memory of what was happening. The court looked at the state and said, you kind of knew they were going to go this way though, right? Like they appointed the experts. You've heard them rumbling about this. You're aware. So even if they didn't file it, you're not being caught completely off guard. So you're going to have to roll with it and made the state roll with it a bit. So I appreciate the footnote. The court made the state deal with it. As to the battered spouse syndrome defense, the state argued the notice was insufficient because it did not include any particular facts which would allow Dr. Julie Harper to opine that Boone suffered from the syndrome. And then they're citing the record and different pages of the record, which is why you see the R period and then page numbers. So they're citing the record that they have and was filed with them in advance. The state moved to exclude Dr. Harper's testimony as it would be based on inadmissible hearsay of Boone's statements and argued that Boone should be precluded from mentioning the battered spouse syndrome in her opening statement. The state noted that Boone had previously told law enforcement that she had accidentally left the victim in the suitcase overnight and that the battered spouse syndrome testimony is not admissible if the defense was that the killing was an accident. Can't have both. And you can see why those are inconsistent, right? The arguing that this is an accident is incredibly different than saying, yes, I did this, but I had a reason to do it. It's because I was so afraid for my life that I had no other option but to respond to that fear with lethal force. Either accident or so afraid that lethal force was in fact justified. But those things are completely inconsistent with one another. They go on to say that the state also requested that Boone submit to an examination by a state expert. Boone filed a response to the state's combined motion, arguing that the notice was legally insufficient, that the defense should be allowed to reference the syndrome in opening statements. The state filed a motion to strike the amended notice of intent to rely on the defense, footnote 2, arguing that what Boone allegedly did not meet the criteria for battered spouse syndrome, and that the discovery did not support a diagnosis of battered spouse syndrome where Boone claimed the killing was an accident. CEG what I just said. Either you are terrified and you are acting knowingly based on that terror, or whoops-a-doodle. Those aren't the same. The state moved to prevent any mention of battered spouse syndrome until admissible evidence of a justified use of deadly force was admitted into evidence. Again, not uncommon in self-defense cases. Until you get to the self-defense part, it's often limited. It's the same with like third-party culprit defenses. Until you've met some thresholds for that to come in front of the jury, you can't bring it up. Let's see. The footnote 2 says it does not appear that the amended notice was included in the record on appeal. Well, that's frustrating. Emily, who makes sure that the record is complete on appeal? The person making the appeal. Aren't they appealing on the court denying them use of demonstratives in opening statement regarding this defense? Yes. Does it seem that they forgot to include their notices? Yes. It seems that they forgot to include all of their notices. That's annoying. I would footnote that too. Every single time I would footnote, excuse me, I looked for these. They're not on the record that you submitted. Yeah. Where are those? Because it's not up to the appellate lawyers to go find them. It's on the filing party to submit the entire record. Yeah, that would annoy me too. That would annoy me too. Yep. I would 100% footnote that and be like, but you didn't give it to them. You didn't give it to us. But if they didn't give it to them, the appellate court can't consider it either. So it only hurts the defense to not have a fully submitted record. There is a lack to attention of detail that is deeply annoying. Okay, it's appellate work. Detail is the whole thing. Moving on. The court granted the portion of the state's first motion in that Boone was ordered to submit to an examination by a state expert. The court declined to strike the notice of intent to rely on the battered spouse syndrome defense and denied the state's request to preclude Boone from mentioning it in opening statement. So you were allowed to mention it in opening statement. This came up in Boone's argument where they were arguing they weren't allowed to say it, and then they kind of acquiesced that they were allowed to mention it and they just weren't allowed to use photos. And by the time we got to the end of that, we're like, oh, okay, sure. Kathleen, this is fair. Kathleen in the chat said, I think the defense attorney knew no true appeal existed and put something together for the sake of it. I would offer back that most attorneys can kind of argue anything, and it's a choice. They could have argued the jury instruction. They could have argued the things that Owens put in his notice of appeal. There was an outburst in court. I don't think that's a great appealable issue, but they could have made that issue and raised it. So they didn't have to raise this about opening statements. They could have appealed on just one issue, the jury instructions. So they've made this a matter where they didn't need to make it a matter, and then they've not done it well. So at least if you're going to throw it up there, include your notices that you say were denied. It's just frustrating, the lack of attention to detail. They go on to talk about the motion in limine, saying that the state filed a motion in limine to exclude the battered spouse defense or to exclude mention of it until the appellant testifies to a justifiable use of deadly force. The state noted that based on the depositions of Dr. Harper and the state expert, Dr. Warner, Appellant Boone told both experts that because of past violence between her and the victim, she had a generalized fear every day that the victim would cause her serious bodily harm, but that on the day of the killing, the victim did not take an overt action that made her believe he would cause her serious bodily harm or death. She said, I'm afraid of him all the time, but didn't say, and then on this day, he did thing A, B, or C, and I was responding to thing A, B, or C. And that's part of the problem here. They go on to say in the state statement of facts that Boone's version of events was that the victim, after drinking all day, suggested a game of hide and seek. Victim hid in a suitcase. Boone saw him do so and decided to zip the suitcase shut while he was inside. They were both laughing. She asserted that the suitcase was not completely shut and that the victim could poke a couple fingers through, that the victim could not breathe and became angry. This is the state retelling of Boone's side of events. That victim could not breathe and became angry. Because the victim was angry, she became angry. The situation reminded her of past violence where she was unable to breathe, and she wanted the victim to feel what it was like for her to choke and not to be able to breathe. Sounds like a first. Filed like a second. Sounds like a first. Does that sound like she is afraid, or does that sound like she is seeking retribution or retaliation? She said she wanted the victim to feel what it was like for her to choke and not be able to breathe. She hit the victim's fingertips with a baseball bat. Having hit the victim, she believed he would kill her. She flipped the suitcase right side up and believed that he would let himself out. So she was afraid that he was angry that when he got out, he would harm her. So she then fled the house, called law enforcement, did anything that indicated that she was afraid. No, she went upstairs and went to bed. She was afraid that he was angry and that he would harm her when he got out. They say that Boone believed that George, the victim, would kill her. She flipped the suitcase right side up, believed he would let himself out, did not intend to kill him. The state argued that the battered spouse syndrome evidence was inadmissible if the defense was accident rather than self-defense. Like, you can't have two. Thus, they say Boone should be required to present evidence of an overt act by the victim that justified a self-defense claim before any evidence came in. At the hearing, the court asked for a factual basis that Dr. Harper used to formulate her opinion. Defense counsel answered that it was based on her interactions with Sarah Boone. When asked what overt act gave rise to self-defense, defense counsel responded that evidence of an overt act had to come from Boone at trial. See how circular that is? See how circular that is? What's the overt act? Well, Boone will tell you at trial. Okay, but what's the overt act? Well, she'll tell you when we get there at trial. Okay, but you can't bring it in at trial until we know what it is. Defense counsel argued that this situation was not appropriate for a pretrial ruling. What defenses are being presented at trial is of course completely appropriate for a pretrial discussion, even if it's, well, until this, then that. Gail said, did she flip the suitcase? I don't remember seeing that. She testified that she did. And there was conversation about the suitcase being turned over, but the testimony didn't make a lot of sense about the suitcase being turned over, because how are you turning it over? And how would it be zipped up if it was laying on the zipper side? It did not make a lot of sense, but there was testimony about that. But it was confusing, and it was particularly confusing when the neighbors testified. Oh, that's right. Serenity 4 said between the two videos, the suitcase was flipped over. That's right. In the video. So at some point, she zipped him in, and then the suitcase was zipper side down because the zippers were on the opening on the top of the suitcase. It was not a clamshell suitcase. And then it was back over. His autopsy indicated that more happened than it just being flipped over. But that's right. But also it doesn't make a ton of sense. Like, if she zipped it up, why did she flip it over if she didn't want him to get out? She did testify on the stand at trial, and then she got on the stand for her sentencing as well. So continuing on, defense counsel agreed that Boone had to testify before Dr. Harper could, and that she had to present evidence of an overt act. Defense counsel argued that this situation was not appropriate for pretrial ruling. The state responded that unless they are saying, this is a direct quote, unless they are saying that the testimony will be different at trial, it was asking the court to prevent the defense from presenting anything about the battered spouse defense in opening statement. Defense counsel argued that it was not the responsibility of the defense to present their case at a pretrial hearing. Oh, I remember this. And that the court was forcing them to disclose what our view of the overt act is. That's a direct quote. Defense counsel asserted that the overt act was the victim's hand, quote, coming out of the suitcase, meaning that he was about to get out. At trial, that was like fingertips coming out of the suitcase. The court denied the state's request to exclude the defense outright. However, the trial court ruled that there needed to be sufficient predicate evidence for self-defense and precluded any mention or expert testimony regarding the defense until the necessary predicate had been established. This is how courts rule almost any time there's an affirmative defense. There are thresholds that need to be met before it comes in. Because when you're shifting into affirmative defense, and by affirmative defense, I mean proving that something happened as a defense. The defense can choose that. Affirmative defense does not mean they didn't prove it, there's not enough evidence, some other dude did it, whatever, unless it's a third-party culpability, but just the general, it wasn't me. Just the general shaggy defense, it wasn't me. Those are not affirmative defenses. The defense can rely on they didn't prove that you did it, they didn't prove there was enough intent, who can trust this evidence anyway, all of that. But when you take an affirmative defense like self-defense, then the defense has to prove some things affirmatively because they are making that choice. They're not obligated to, they're choosing to. When defense counsel, this is back to the motion, when defense counsel asked for clarification, the court stated, quote, if you want to mention it in opening, you can mention it in opening. There's no preclusion from you doing that. Telling the defense, if you want to say that the evidence will show that Sarah Boone was acting out of fear, go off, I guess. But you can't show the photos. Prior to opening statements, the state informed the court that the defense had indicated that they intended on using demonstrative aids during opening statement, including jury instructions and photographs. Defense counsel agreed not to use the, quote, blow up of the jury instructions on the justifiable use of force. Because it's not argument. Defense counsel indicated that it wanted to use photographs in its opening depicting 1, Sarah Boone after the victim's arrest in a previous incident with blood on her ear, 2, Sarah Boone on her back porch with dogs, 3, the inside of the townhouse, 4, the TV with holes in it from where the victim hit it with a bat, 5, injuries to Sarah Boone's left arm, 6, a wound on Sarah Boone's leg, 7, Sarah Boone's face where the victim poked her with a curtain rod. That was a direct quote. 8, a close-up of Sarah Boone after she was kicked in the head. 9, a close-up of Sarah Boone's face after she suffered injury by the victim. The defense believed that the exhibits would be introduced as evidence and argued that the demonstrative aids would assist the jury in understanding the actions appellant took and the reasonableness of those actions. That's argument. That's argument. That's argument. The state requested that the court utilize its discretion and not allow either party to use exhibits during opening statements. Also, chat, can we talk later about Xzibit, not Exhibities in court, but Xzibit, the rapper's cat, Thundercat? Because I don't know how this just came across my social media, but damn, that's a cute cat. We'll have to talk about it later. We'll have to talk about Xzibit, the cat dad later, remind me. But the use of exhibits during opening brought that up. Other exhibit. The state requested the court to utilize its discretion, not allow either party to use exhibits during opening statements. Chat's like, yes, it absolutely can. Perfect. Thanks, chat. As prior instances of violence or reputation evidence of the victim are not admissible until self-defense had been established, it was unclear whether the photographs would be admissible. Remember and this is a different circumstance, but remember in the Walsh case, how much came in an opening statement that then didn't come in at trial? Right. There is a reason to limit what is said in opening statements. I think the lawyers should make that choice, but the court can do that because you can't mention it until it comes in. Because Sarah Boone could have said, oh, I'm not testifying. And then all that stuff that comes in an opening can taint the jury and it never comes in. It was a huge issue in the Walsh case. And I think because the Walsh case is... I think because the facts of the Walsh case were so horrific, the state didn't make a huge deal about it. though they could have. And I think the defense attorney seemed mortified because I think that Walsh was the one who left their defense attorney hanging out there. But most courts will say, look, until this threshold is established, it's not coming in. Going back to the motion, they say that the state acknowledged that the parties could go into things in opening statements that didn't end up coming into evidence. But if the defense was permitted to show photographs that ultimately were not admissible instead of just talking about it, quote, it's an error the state has no remedy to fix. Right, because what's the state's remedy? The state can't easily ask for a mistrial and can't always be granted a mistrial. And so what do you do then? The shit's out of the horse. The court held that, and then this is a direct quote. The court held that, quote, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, they must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Again, I think this was a close call on allowing this defense at all, but I think the court erred on the side of the defense, as courts tend to do once you get to trial. I think that's a close call. Did the fingers pointing, like the tippy tops of the fingers out of the suitcase zipper, is that an overt act at or about the time of the incident that reasonably indicated a need for self-defense? The court went on to say, and this is being quoted in the state's brief, I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature, the lacerations, sutures, bruising, facial wounds with bleeding, may have such an impact such that the toothpaste cannot be placed back in the tube. Emily, keep reading. It's the court's version of the shit's out of the horse. Right. Can't put the toothpaste back in the tube. So the court says if we show those photos and then they're not admissible, it's too late. The court again, and this is going back to the motion, quoting it, the court again takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So the court is going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about some instances that may have happened, but I'm not going to allow the photographs at this point. Why? Chat, I'm asking you, why? Because photographs are more powerful than words. You can describe something and it doesn't have the same impact as a photograph or a video. It's not the same. And the courts are aware of that. The court goes on to say, I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Again, they can come in during the case, they can come in during closing, but not in opening. In its opening statements, defense counsel asked the jury to find appellant not guilty because she was justified in the force used based on the circumstances that existed between herself and the victim. Defense counsel discussed the domestic violence by the victim and indicated that photographs of her injuries existed. On the 911 call published at trial, Sarah Boone told 911, quote, my boyfriend and I were playing last night and I put him in a suitcase and we were playing. On the body cam video, when officers arrived at the scene, Sarah Boone asserted that when the victim got in the suitcase, she was going to joke with him and zip the suitcase, but then she fell asleep. Sarah Boone also asserted that the victim's family, quote, would kill her because they think that she killed him. They left some of that out too. She invoked some Yu-Gi-Oh! In that later. The crime scene investigator, Melissa, is that Roughgarden? Roughgardn? Roughgarden? How did I not remember this last name? Melissa Roughgarden testified that the zippers on the suitcase did not have zipper pulls on them. When asked whether it was easy to operate the zipper, the crime scene investigator Roughgarden testified that it was a little difficult. There was blood inside the suitcase. Well, where did that come from? There was blood inside the suitcase. When she photographed Boone did not indicate she had any injuries. The victim had blood on his mouth and nose, and there were some other areas of this is a direct quote, there were some other areas of defects noted on his body. That's direct quote. Dr. Sarah Zadowitz, the medical examiner, testified that there were blunt impact injuries on the victim's head, around the eye, and mouth area. There was some ecchymosis, which could be thought of as a large kind of bruise on both hands. There was also a series of ecchymosis on the left side of the victim's back and on the forearms, and there were at least 5 or 6 blunt force injuries. They talked about this at closing. Do you remember the prosecutor grabbing the baseball bat and hitting the suitcase during closing? It was wild. We did hear about blood in the suitcase during trial because we heard about the injuries to the victim, but so much happened after that, early days, that by the time we got to the rebuttal, there was so much else happening. Let's see. They say there were 5 or 6 blunt force injuries. The victim was 62 inches and weighed 103 pounds. He had a blood alcohol level of 0.139. Emily, is that high? Yeah, that's high. That's real high. That's high. The cause of death was positional asphyxia with environmental suffocation, and the manner of death was homicide. So the environmental suffocation is being closed into the suitcase. The positional asphyxia is the way that he was in the suitcase. The digital forensic examiner, that's the right word that we were looking for. Ueden testified that she extracted the data from Boone's phone. 2 videos are found depicting the victim in the suitcase. The first was made at 11:12 p.m. and lasted approximately 2 minutes. And then there's a footnote to that. On the video, the suitcase was facing lid side down. Chat, your memories are so good. Your memories are so good. On the video, the suitcase was facing lid side down, and the victim called Appellant's name and told her that he could not breathe, and she laughed and told him, "Fuck you." The second video was made at 11:23 a.m. Lasted, so what's that, 10 minutes later? Lasted 22 seconds. Footnote 5. It depicted the suitcase lying on the floor and the victim calling Appellant's name. Detective Kelsey Kopsel testified that she interviewed Boone. Boone asserted that she and the victim were, quote, enjoying each other's company when they decided to play hide and seek. And that when the victim hid in the suitcase, he was, quote, being silly. He and I were sitting there laughing at it, like with him in there. Yeah, in addition to saying, fuck you, he kept saying, Sarah, I can't breathe. And she was like, that's my name. Don't wear it out. The videos are chilling. And the footnotes indicate where the videos can be found on the record so that the court can review them if they need to. This is continuing on Boone's interview with law enforcement in the statement of facts from the state's argument on appeal. When the victim hid in the suitcase, he was, quote, being silly. He and I were sitting there laughing at it, like with him in there. Boone did not zip the suitcase all the way because, quote, both fingers were out there and whatever. That's a direct quote. They were still having a good time, and Boone decided to go upstairs and fell asleep. Boone asserted that she did not know what happened and that she and the victim, quote, were having an amazing time yesterday, like we normally do. Her police interview was something. Boone asserted that they were not drunk, that they had a handful of glasses of wine throughout the evening. They were drinking mega magnums of wine. She stated that there was no ill will between the two of us last night. She had forgotten at this point about the videos. She had not been shown the videos yet, where she's like, for everything you did to me, fuck you. That's my name. Don't wear it out. Right. There was no animosity. Everything was awesome. Care to explain these videos? It's not intentional. I'm not going to replay the videos or the interview of her with police because it'll just make me mad. But we looked at them during trial. They're time-stamped. I will add later to this video, the day of trial, where they play the police interview in the trial. If you guys want to go look at it, they played these videos a couple times during trial. But if you want to go look at her police interview, I will link the days of trial where they played that below this video later on. They go on to say that during the second interview after the autopsy, the detective confronted Sarah Boone with the victim's injuries. Boone asserted that she had no idea and that she did not touch him. Those blunt force injuries didn't just appear out of nowhere. But she said, I don't know. When the detective confronted Boone with the videos, Boone admitted that she flipped the suitcase over. Boone asserted that she thought the victim was, quote, crying wolf. That's a direct quote from the transcript. Boone asserted that she did not remember making the video because they had been drinking, but reaffirmed that she was not drunk. No, I'm not drunk. I mean, I have no memory of what happened last night, but I'm not drunk. No, I took a video that's going to be used against me at a murder trial. I have no idea it exists. But no, not drunk. After the state rested, Boone testified that at the time they decided to play hide and seek, they were both intoxicated. You don't say. When she saw the victim get into the suitcase, she, quote, zipped him up. They thought it was funny. By they, she means she. They thought it was funny. It goes on to say that Boone, quote, kind of moved it around a little bit with him in the suitcase still. And from moving it around, the suitcase flopped over. Girl. This will shock no one. I sometimes struggle with decision-making in packing. Shocked, I know. All of you are shocked by this reveal. Sometimes my suitcase is maybe more than 50 pounds. And let me tell you what, that shit's heavy. You are talking about a 100-pound human in a suitcase, and it sort of just flopped over. A, you're drunk. B, it's 100 pounds in a suitcase. C, that shit's gonna be heavy. What do you mean it just kind of flopped over? It didn't just flop over. He can't move. He is so wedged in there that it, in fact, caused him to suffocate because he was so wedged in there. It doesn't just flop over, Sarah. That would have taken some effort. She probably doesn't remember the effort that it took because intoxicated. Ah! Continuing on. She said it just kind of flopped over. Whoops-a-doodle. And the neighbor's testimony indicates that that suitcase might have gone from the upstairs to the downstairs. But that was left kind of open-ended. Either way, the victim was injured, and Sarah Boone admitted to using a baseball bat while he was in the suitcase. The prosecutors think that she hit him with the baseball bat while he was in the suitcase more than once. That's what they illustrated at closing. Either way, he was injured. They go on to say that Boone, quote, thought at that point that she had a moment to take time to talk to him a while. He was not able to get out for a moment. She decided to record, quote, For him to understand that right now, she felt safe and had the ability to speak in a manner that she normally would not have the ability to do so. That all got undermined in the rebuttal case, but she could tell the victim was uncomfortable and wanted him to feel uncomfortable. To me, that can be a first-degree murder. I understand why they went with the second, but it's not giving I'm afraid. It's giving I'm in a position of power and there isn't shit you can do. And now you're going to listen to me. He's begging for his life and she's like, you're going to listen to me. During the 11-minute period between the two videos, the victim's tone changed. It did. And they argued. The victim said things that, quote, very much frightened Sarah. She said in the period that the recording was not on that he was scaring her. The victim continued to push on the suitcase. Sarah Boone feared he would get out. The victim's hand started to come through, so Boone shook the suitcase to get his hand back inside or back in. The victim was forcefully trying to get out. Boone believed that had he gotten out, he would have made her, quote, unrecognizable or killed her. Her actions do not follow her statements. She said that she lost her grip and that his hand was still out. However, at trial, it was just like the tips of his fingers. But she lost her grip. His hand was still out. So she grabbed the baseball bat and tried to, quote, poke his hand to go back in. Once the victim retracted his hand, he stopped cursing and threatening her. There's no recordings of him cursing and threatening her, by the way. She said she felt safe enough to turn the suitcase back over, then recorded the 22-second video. She asserted that there was enough room between the zippers for his hand to come out and that she believed he could breathe. She went upstairs. Yeah, she went upstairs and went to bed. Went upstairs and went to bed. At the bench, defense counsel requested that the court make a ruling as to whether sufficient evidence of an overt act had been made to present other evidence. The court found that an overt act had been established, quote, as a scintilla of evidence was sufficient. So the case law in Florida says a scintilla of evidence, like the teeniest slice of evidence, the teeniest bit of evidence is sufficient. And so based on that case law, the court said there is the teeniest indication of evidence and this can come in. And then Boone testified about the prior bad acts committed by the victim against her, and each photograph defense counsel wanted to present was admitted into evidence. So then the photos came in that they had wanted to put in at opening. And this is what opened the door for all of those other videos to come in on rebuttal. I think there were probably more. I think that the state was kind of restrained in that. That would be my guess. But you got the point with what they showed, because they showed the body cam from different instances where she had called the police on him. On cross-examination, Boone admitted that she sent a letter to the victim's family about the woman he was cheating with. I don't remember that. Boone took a photograph of the suitcase at 11:03 p.m. When asked whether the victim was in the suitcase the entire time between 11:03 and the second video at 11:23, she said, I believe so. When asked whether the victim told her that he could not breathe before she took the first video, she responded, I don't remember. That's probably true. Dr. Michael Brannon, a forensic psychologist, testified generally regarding battered spouse syndrome on cross-examination. The doctor agreed that it was important to conduct a comprehensive evaluation with as many collateral sources as possible when assessing for battered spouse syndrome, and that both a person accused of committing a crime and a person with an alcohol abuse disorder had credibility and reliability issues. So do we have, is Sarah Boone a reliable narrator? The jury thinks not. I think not. Yeah, I think not at all. Let's see. Dr. Julie Harper testified that she first conducted a comprehensive psychological evaluation of Sarah Boone in June 2020 and had met with her 9 times. Dr. Harper administered 3 psychological tests, reviewed the background history, her prior mental health records, her interrogation video, and, quote, some prior information about her legal history. Dr. Harper believed that Boone displayed some narcissistic traits. Shocking. The only reason chat didn't talk about it more during her police interview video is because we don't diagnose people. However, chat has very, very high pattern recognition. And so the difficulty with don't diagnose people and everyone's pattern recognition was real hard during Sarah Boone's interview with law enforcement. Yeah, it was real difficult. It was real hard. It was real hard, but we did it, chat. Dr. Harper concluded that Boone suffered from trauma as a result of intimate partner violence. Dr. Harper diagnosed her with PTSD, depression, and alcohol use disorder. Dr. Harper opined that Boone was suffering from battered spouse syndrome at the time of the murder, explaining that Boone had patterns ingrained in her behavior that would be typical of a victim responding to traumatic events in a predictable way, so that would fit that. It seemed to me that Boone's response is when she was having issues with George, she would attack him in a berating way and then would physically abuse him. And that's based on the videos we saw. And then she would take videos of him responding to her abuse and say, see what you do to me. And he was also dealing with a deep alcohol dependency. And so she would just gaslight him and just be like, see, this is what you did to me. It was crazy. But were there times that Sarah Boone was also harmed? Yes, there were. Absolutely. So I think the jury kind of saw through that once they got to the rebuttal videos. Let's see. On cross-examination, Dr. Harper explained that battered spouse syndrome was not an actual diagnosis in the DSM. There was no specific written criteria or standardized approach. It's PTSD based on intimate partner violence is really what it boils down to. And then the response is explained through that lens. They go on to say on rebuttal, the state presented Dr. Tanya Werner, who testified that not all violent episodes within a relationship resulted in battered spouse syndrome. She evaluated Appellant on October 2nd as the request of the state and pursuant to a court order. I think the state was at a bit of a disadvantage with this because by the time the state was evaluating Sarah Boone, she had had plenty of time to decide that this is the defense that she was going with. So I think the evaluation was skewed by Sarah Boone's own efforts because it wasn't closer in time to the incident. It was closer in time to her going to trial when she had already decided this is why she is going forward, or this is the defense she wanted to go forward with. Let's see. The evaluation on October 2nd was right before trial. Both the prosecution and the defense attorneys were present. Dr. Werner summarized the version of events as provided to her by Sarah Boone. Dr. Werner explained that alcohol could affect a person's memory. Thank you for that. Or a person's response to different things. Dr. Werner opined that Appellant did not give me enough information to diagnose her with PTSD at the time that I evaluated her in the jail. Fair. That's fair. Defense counsel objected, explaining that when he deposed Dr. Werner on October 4th, 2 days later, she asserted that she had not formed opinions as to whether Boone suffered from a specific disorder. The parties agreed that if Dr. Werner formed any opinion, the defense would be notified, but the defense was not notified. The parties reviewed Dr. Werner's deposition, which stated, and now this is part of the deposition that the defense did. Not all jurisdictions allow for a formal deposition of witnesses in a criminal case. Florida does. Question. Okay. Do you feel like she suffers from post-traumatic stress disorder? Answer, she didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her. She talked about that, and she spoke about, having recollections, remembering abuse from George during the evaluation. But those were the things that she spoke about that would go with that. Question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion? No, I would have to look back through my notes to see if she fully met the criteria. Question, can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, no, I didn't say one way or the other. I would have to look back through my notes for that. Question, is that something that you may in the future give an opinion about after some time reflecting and reviewing your notes? Answer, I may. So this is the question and answer from the deposition, and the defense is saying that this doctor changed her position at trial. Does that seem like a change in position? Or does that seem like, I did this evaluation 2 days ago and I need to review my notes? Because I haven't decided yet. Is that something that you may in the future give an opinion about after some time reflecting and reviewing your notes? I may. Though when the doctor made that opinion, it should have been given to the defense, 100%. The state argued that Dr. Werner's opinion had not changed. When the court asked what the legal objection was, defense counsel argued, I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of a change of opinion and I would be allowed to take a second deposition. Remember, this is all happening in the days running up to trial. And I believe, I should just keep reading, but I believe that what the court found was that the doctor didn't give the state any other information. But when asked about it on the stand, that's when she's like, oh no, I reviewed it more and I don't think she met the criteria. But I don't think the state got it. But it should have been given to the defense. When the court asked for a legal objection, defense counsel said, I don't think there's legal grounds. It's just vibes, Your Honor. Vibes. They promised. No takesy v backsies, Your Honor. They said they'd let us know. The state responded that when it spoke with Dr. Werner the day before, she had indicated that there had been no change in her opinion about any diagnosis. Defense counsel asked that the remainder of Dr. Werner's testimony be proffered because he did not know whether her opinions had changed. Proffered means voir dired outside the presence of the jury. Dr. Werner proffered that battered spouse syndrome or PTSD was not related to the incident as she reported it, Sarah, regardless of prior instances of violence. When asked whether any materials would change her opinion based on what Boone told her about what happened, she said no. Defense counsel argued that Dr. Werner had given a legal opinion that PTSD did not apply in the case and argued that there had been a discovery violation. Okay, I can understand where they're arguing it. She said, I don't think this relates to the incident as Sarah Boone told me about the incident. And the defense is saying she's coming to a conclusion on ultimate opinion during trial. The court asked where the change in testimony occurred. The defense counsel pointed to the portion of the deposition where Dr. Werner agreed that she had no opinions other than the ones provided in her deposition. Counsel argued that it was a discovery violation because he should have been notified of the change. The court again asked what opinions had changed. Defense counsel asserted that he would have to ask the clerk to reread the question and answer. I remember this. The court found, and now this is the court's finding at the end of the argument and at the end, I don't remember if it's at the end of the doctor's proffer or before. So let's just, Emily, keep reading. What did the court say? Quote, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter. The readback of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertaining to the opinions by the defendant as to whether or not the defendant suffers from PTSD. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition, as identified by the defense, identifies that if there were any additional opinions, that they would be notified. So the court's kind of like, yeah, but this is a solidification of what you believed, and the defense should have been notified. I don't think the state was notified either, but doesn't matter. The court held a Richardson hearing. This is a discovery violation hearing. On the alleged discovery violation, the court found that the violation was inadvertent based on the state's proffer that Dr. Warner had agreed that there had been no change of her opinion. So Dr. Warner's like, I didn't change my opinion. However, we're now kind of splitting hairs on that her opinion was solidified. So to the defense, a more solid opinion is a change from, I have to review my notes. So I understand where the defense is arguing, and I don't fault them for that argument. But I understand where the doctor's like, I didn't change my mind. I just solidified it. So I get where, looking back on this, I get where the court is like, we're not going to split hairs that finely. The court found that the violation was substantial with regard to the opinions based on the testimony and Dr. Warner's deposition, that any other additional opinions would be notified to the defense. The court found that although the question in the deposition did not address the opinions currently being offered, it had impacted Boone's ability to properly prepare. So they're also splitting because there's a difference between general PTSD or PTSD more broadly, and then the incident here. The court agreed to oversee an in-court deposition of Dr. Warner with regard to the proffered opinions. In this deposition, Dr. Warner explained that that PTSD did not apply in this case because of the way that Boone described the incident to me, and that this was her opinion when her prior deposition had been taken. Splitting hairs, it seemed like a solidification of her opinion, but I think during trial it felt, and maybe this is just me remembering the vibes, but during trial it felt a little bit evasive. Like, oh, I'd have to review my notes. Oh, well, as she said it to me, it felt a little bit evasive. And the defense was like, but you said that you didn't have an opinion. And she's like, no. I said it about generally, not about this incident. But that's vibes on what I'm remembering, that it wasn't clear. And honestly, I expect more from experts. I expect them to be clear, especially, and I am more critical of state experts in criminal cases. I do not expect the hiding the ball. In civil cases, we're going to see that sometimes. I do not expect the hiding the ball when it comes to a state's expert like this. We're here to get to the truth, not to split hairs and play word games. So I remember this being frustrating. Also, the defense was just like, I'm trying, Your Honor. I'm trying. So the court agreed to oversee the in-court voir dire. In this voir dire, Dr. Warner explained, and they're calling it an in-court deposition as well. So, I withdraw snapping about the previous filing, calling it a deposition. They're calling it a deposition too, fine. In this in-court voir dire, Dr. Warner explains that PTSD did not apply in this case because of the way that Boone described the incident to me, and that this was her opinion when her prior deposition had been taken. When asked why she did not inform defense counsel about this opinion, she said, "You didn't ask me about that, sir." Let's just go back to this part that they ask? Can you explain why you don't think she suffers from PTSD? No, I didn't say one way or the other. I would have to look back at my notes for that. Come on. The defense is asking you about whether you think she suffers from PTSD. And she's saying, but you didn't ask me if you thought PTSD applied at this incident. Okay. You didn't ask me about that. All right. I had to scroll back and look. Let's get back to where she was like, but you didn't ask. Back in front of the jury, Dr. Warner testified that irrespective of any opinion as to whether Boone suffered from PTSD or battered spouse syndrome, neither disorder had any relation to the instant offense. Dr. Warner explained, quote, the whole part where she's describing the part about playing hide and seek, that they were having a good time, that they were laughing when he got in the suitcase, when she found him, that they were enjoying themselves, she zipped him up and they were laughing, they were having a good time. All of that isn't consistent with her having a feeling that she's at imminent risk or imminent fear that there was an imminent risk of harm. That part I understand. Right. The event she's describing is not her describing being in terror for her life of her abuser. She's zipping him into a suitcase and laughing at him. That's not the same. That's not her being in fear. Defense counsel objected, arguing that the testimony went to the ultimate issue of fact, which was for the jury to decide. The state responded that it was no different than an expert testifying as to insanity. The court noted that the opinion did not go to any one of the specific elements. The court overruled the objection, finding that the testimony did not go to an ultimate issue of fact as addressed by Section 90.703. On redirect, Dr. Warner explained that even if someone had battered spouse syndrome, it did not necessarily mean that any action they took against their partner was justified. The state requested a jury instruction on forcible felony and initial aggressor, arguing that Boone committed independent forcible felonies prior to deciding to leave the victim in the suitcase after at least 20 minutes, and that Boone was the initial aggressor. After the charging conference, that's the conference where they talk about the jury instructions, the state argued that Boone had a duty to retreat because she was the initial aggressor when she used force by zipping the victim into the suitcase. Defense counsel objected, arguing that there was no duty to retreat because the victim entered the suitcase himself and the zipping was consensual. Some of you who watch this trial are like, I remember these arguments. Right. The state responded that the victim was held inside the suitcase against his will and that there was sufficient evidence to dispute whether Boone was the initial aggressor. The state explained, quote, and they are reiterating the state's argument. And this is the state's argument on that point at the charging conference. So you notice, even in the statements of fact, the state's appeal has walked through each point that the defense will be arguing in order. Right, it's easy to follow. Quote, she restrained him in the suitcase on purpose and intentionally. And if you look at the elements of aggravated assault in our proposed jury instructions, that is exactly what was going on. She intended for him to feel fearful of an inability to breathe, to make him feel like he had made her feel when he had choked her. An aggravated assault is defined as follows, quote, Sarah Boone intentionally and unlawfully threatened, either by word or act, to do violence to George Torres. She would not let him out. She would not release the headlock when he indicated he could not breathe. So this is their argument for why this instruction should be given. It continues with the state's argument at trial, saying, quote, at the time Sarah Boone appeared to have the ability to carry out the threat, the video evidence is res ipsa loquitur. Just a 10 out of 10 pause. I'm sure I was thrilled at the time. I'm thrilled again. Anytime we get to res ipsa loquitur, Emily's a happy girl. We love it. 10 out of 10 for the prosecution. Hold on, where's our applause? The kids go wild. 10 out of 10. 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 Res ipsa loquitur simply means the thing speaks for itself. It is what it is. The thing speaks for itself. The video is the video. You can go see it. It is what it is. It goes on to say the state's argument during the charging conference, quote, he could not get out on his own. He could not get out on his own at 11:12 in the first movie. He could not get out on his own at 11:23 in the second movie. And quite frankly, he couldn't get out at 11:03 during the still photo as well. Element 3, and they're talking about why this instruction should be given. Element 3, the act of Sarah Boone created in the mind of George Torres a well-founded fear that violence was about to take place. Absolutely. And then they're quoting what George was saying. Sarah, I can't breathe. Babe, I can't fucking breathe. Sarah. And then Sarah said, shh, go fuck yourself. And that's my name. Don't wear it out. The state goes on to argue the assault was made with a deadly weapon. Element 4, an object not designed to inflict bodily harm may nevertheless be a deadly weapon if it is used or threatened to be used in a manner likely to cause death or great bodily harm. I have seen GBIs with just about anything you can imagine. Hot water being one of them, because hot water can cause death or great bodily harm. Scissors, not generally intended to inflict bodily harm, but can. Skateboards, baseball bats, etc. They're talking about like not a gun, not a machete, not a sword, but other things that can cause harm. Anything. There are lots of things that can be used to cause harm. In this case, a suitcase. It doesn't have to be a traditional quote unquote weapon. Let's see. I thought this was the state arguing to the court. It seems like this might be the state arguing to the jury. That wasn't clear to me when I started reading this, but now at the end, it seems like we're talking about closing argument because the state then says, well, ladies and gentlemen, it did cause death, so it's not in dispute. So it's our position that she was the initial aggressor based on her testimony that we received in court, and that it's going to put into play a duty to retreat, and that the parties can then make argument about that. I still think they're arguing to the court. I don't know where the ladies and gentlemen is coming from, but whatever. We're moving on to see what the appeal goes on to say. That was a bit confusing. I thought they were arguing to the court. Continuing on. The court noted that the form instruction said that if the parties disputed whether or not there was a duty to retreat, the court should instruct the jury as such. And as there was a dispute, quote, I think I have to, based on what the Florida Supreme Court's instruction to me is, to give the second paragraph. So what they're saying is that if there's a dispute about initial aggressor or duty to retreat, then there's an instruction saying if there's a dispute, then you have to give this. And the court's saying based on the Supreme Court, I have to. The state's proposed instruction in relevant part read, quote, on the other hand, 1, if at the time Sarah Boone used deadly force, she was committing an aggravated assault, then the defendant had a duty to retreat. Defense counsel objected, arguing that the state did not charge an aggravated assault in the information. They don't have to. They don't have to. You can... What would the point be? Like for real, what would the point be of charging an aggravated assault for zipping him into the suitcase and then charging the murder based on the suitcase? They would merge into each other. There would be literally no point because no jury can find that, yes, she assaulted him by zipping him in the suitcase, but no, she didn't cause him to die. It just doesn't make any sense. So why would they charge him or charge Sarah Boone with that? They don't have to get the instruction. The state explained that Appellant testified that when the victim stuck his hands out of the suitcase and threatened her, she decided not to let him out and he died, which was second-degree murder. However, what preceded that was her not letting the victim out when he begged her to do so because she decided to teach him a lesson, which was a separate aggravated assault. The state explained that it would have charged Appellant with aggravated assault and aggravated battery as separate offenses, but that it did not discover the information until after the statute of limitations expired. Okay. The state argued that the purpose and spirit of Martinez, that's case law, was to make sure that the state did not argue that the defendant had no right to defend herself from an imminent threat or harm by killing someone. And then they cite Martinez versus State in the footnote. They go on to say that the court found that pursuant to the Martinez case, the forcible felony instruction could not be read unless the defendant was charged with the independent forcible felony. So there's that. We would have charged it. Again, this is why you need to practice in the jurisdiction, because if you're not allowed to make the argument unless you charge it, then the reason to charge it, even though it merges at sentencing, is so you can make this argument. The court found that pursuant to Martinez, the forcible felony instruction could not be read unless the defendant was charged with that independent forcible felony. The court asked how to address the duty to retreat instruction if it could not mention aggravated assault. The state responded that it could just assert that appellant had no duty to retreat and they could, quote, deal with the initial aggressor at the end. Defense counsel objected to the initial aggressor instruction because appellant testified that she did not do anything until after the victim threatened her. The court ruled that the jury would be instructed on the initial aggressor. Both parties agreed to the instruction on battered spouse syndrome. So they walked through this. I vaguely remember them walking through it at trial. I probably made the same argument then and went, oh, well, the law in Florida is different, so you can't do that. Sure. So then we get all the way down to, okay, but you can still give the initial aggressor instruction. During closing, the state argued that Boone initially provoked and the threatened use of force against herself. So did Boone do something that made him try to put his fingers out and try to escape? During closing, the defense presented exhibits. The jury found appellant guilty as charged. Appellant was sentenced to life imprisonment. Summary of the argument. We're 24 pages in on the facts. The state was like, we agree with the defense facts. We'll just add a few more. 24 pages later. 24 pages later. Summary of the argument. The trial court did not abuse its discretion in limiting appellant's opening statement. I don't even think they limited the opening statement because they limited exhibitees. They limited demonstratives. They can't even be exhibitees in opening because they haven't been admitted yet. They limited demonstratives. That's not unusual. The state says, contrary to appellant Boone's argument, the court did not rule that she could not introduce evidence of the victim's prior violence. Instead, the court merely precluded the defense from using demonstrative aids during its opening statement. 2, the second issue they say is unpreserved for appellate review because Boone failed to object to the proposed remedy below. Further, the trial court did not abuse its discretion or commit fundamental error in designing its remedy. Additionally, Boone waived or invited the error when it declined to have Dr. Warner's testimony stricken. Wait, they never asked to have it stricken? Oh. Well, that's a problem. That's a problem. 3, the trial court did not abuse its discretion when instructing the jury on the initial aggressor instruction. 4, the trial court did not abuse its discretion in overruling defense counsel's objection to Dr. Warner's testimony. Although Dr. Warner provided an opinion that went to the ultimate issue to be decided by the trier of fact, it did not tell the jury how to decide the case. That's somewhat of a concession. All right. Let's see. The trial court did not abuse its discretion in limiting appellant's opening statement. So now we're moving into the arguments. That was just a restatement of what the arguments are. We're moving into the arguments. The trial court did not abuse its discretion in limiting appellant's opening statement when it precluded appellant from using demonstrative aids. I just agree. I don't know how much I want to read this because I just agree. This is just correct. How many ways would you like me to tell you correct? This is just correct. They weren't stopped from saying anything. They were just stopped from showing images that, had Boone decided not to testify, which she could have done, can happen, would not have come in at evidence. That's reasonable. I don't know why this is the first point on appeal. I think it is a silly first point to make on appeal. I think they should have led with the jury instructions and gone from there. This should have been their last point on appeal because it is their weakest argument. I agree with the state. I agreed with the state before the state responded. They say that appellant argues that the trial court erred in improperly limiting her opening statement regarding the overt act requirement. The state respectfully disagrees. I disrespectfully disagree. This is a dumb argument. You shouldn't have made it. Don't do that. They say that the trial court has discretion. The trial court acted within its discretion. The trial court did not abuse its discretion. And then they quote the trial court directly. If you want to mention it in opening, you can mention it in opening. There's no preclusion from you doing that. Period. And then they go on to cite what they cited above in the facts. We are not going to rehash it. We went through it. The court said you can't show the pictures. You can't put the toothpaste back in the tube if you show the pictures, but you can talk about all of it. The state says, contrary to the appellant's argument, at no point did the court rule that, quote, appellant could not introduce evidence of the victim's prior violence to frame a battered spouse syndrome context and thus force the appellant to provide a limited opening statement that did not properly frame Boone's theory of defense for the jury. And then they are quoting the Boone opening brief in that. They go on to say, okay, Your Honor, they're just wrong. They argued this and they're just wrong. That's not what the court did. And the state says instead, the court merely precluded the use of demonstrative aids while explicitly allowing the defense to discuss the prior instances of violence. Let's see. They go on to talk about the fact that, again, it was just the demonstrative aids that were limited. I'm skipping the rest of it. I agree. I think they framed the question wrong, but I do think at the end of Boone's opening brief, they kind of hinted that it was just the demonstratives that were limited. But the court clearly said, I'm not saying you can't say it. I'm saying you can't show it. Next issue. Let's talk about what's unpreserved for appeal. In the second point of her appeal, Boone argues that the trial court did not provide an adequate remedy for the state's substantial discovery violation. The state respectfully disagrees. The issue is unpreserved for appellate review because it was not raised below. Being raised below means that the issue they're raising on appeal was not raised at the trial court. The objection wasn't made. There can be appealable issues at trial, but if the defense doesn't object, and if the defense doesn't preserve the issue and protect the record, you cannot bring it up later. You can't wait, not complain about it at the trial level, and then complain about it later. When there are times I get frustrated with the defense and I'm like, they're just doing their job. This is why. They are doing their job to preserve the issues at appeal. And if you're sitting there going, so the defense has to really be listening through the lens of preserving things for appeal, yes. The defense has to be objecting and preserving things for appeal, which is why there's times where you will see defense attorneys argue something kind of half-heartedly and be like, Your Honor, the defense's position is this. Thank you. And then they sit down. They're like, I know I'm going to lose this argument, but I have protected the record for appeal. I've made the argument. I've asked for the remedy. Even if they don't think they're going to get it, they've made the record. And you'll hear defense attorneys say at times, Your Honor, I just need to make the record. And you'll hear the courts say at time, your rights are preserved, or the record's been made, or your ongoing objection is noted. You don't have to stand up and object every single time. You've made this objection. This objection carries through all of it. The issue is preserved for appeal. Sit down. Now you're just trying to do it in front of the jury, because that's not the thing. You don't get to do performative outrage in front of the jury. Your issue is noted for appeal. Sit down. But there are times where you will see the defense make an argument and just sit down and just be like, I've made my record. I've made my record. Thank you. Bye. Let's see. They say that to preserve the issue for appeal, the quote, specific contention asserted as legal ground for the objection, exception, or motion below must be argued in order to place the trial judge on notice that error may have been committed and allow the trial court the chance to correct the error. They do not want people sandbagging the trial to go to the appellate court to get a do-over. Can you see where that would be a problem? And completely inefficient and just a mess? The goal is to get this resolved at the trial level in front of the jury to have some finality in cases so that only big problems are coming to the appellate court. This is not a big problem. They go on to say that when the court offered a remedy of allowing appellant to conduct an in-court deposition of Dr. Warner with regard to the proffered opinion, appellant did so. Defense counsel did not object to the proposed remedy. Defense counsel complained, excuse me, appellate court, this isn't preserved for appeal. They're just whining. Yeah, they're just whinging about it. This is just bitter Betty. What are we doing? They're just complaining, Your Honor. Defense counsel complained that he did not have the opportunity to speak with his expert about Dr. Warner's opinions and that it put him in a, quote, very difficult situation. Your Honor, he's just whining. However, defense counsel did not propose an alternative remedy or argue that the deposition was an insufficient remedy to cure the violation. But Your Honor, I want to talk to mine. I want to talk to my expert. I need you to recess court for a day or a half day or whatever. After the deposition, when asked whether there were any other arguments, defense counsel responded, quote, no, judge, just what I've already made. Well, what arguments did you make? Your Honor, this puts me in a tough spot. Okay. As appellant failed to object to the proposed remedy, the issue is unpreserved for appellate review. As such, error, if any, may be reviewed only for fundamental error. A fundamental error must reach down into the validity of the trial itself to the extent that a verdict of guilty could not have been obtained without the assistance of the alleged error. So this goes beyond preservation for error. This is an error that is so at the core that it requires a reversal. They say this court is not required to consider fundamental error as it was not raised in the initial brief. And Your Honors, they didn't even bring it up. The only way you can countenance this is with fundamental error, and they didn't even raise it, so you don't even have to. This is kind of an arguendo. Because if the court says, well, let's consider it, this is the state's opportunity to say, okay, even if you get there, still no. So this is the looking forward. They go on to say the trial court did not commit error nor fundamental error in providing its remedy for the discovery violation. And then they walk through the steps that the court took to remedy the violation once they found the violation. Because the court did find a discovery violation, found that it was inadvertent, found that it was actually substantial, and then remedied it by allowing the defense to ask more questions. They say the trial court did not abuse its discretion in providing its remedy for the discovery violation. And at trial, Dr. Warner opined that Boone did not give me enough information to diagnose her with PTSD at the time that I evaluated her at the jail. Defense counsel objected, arguing that when he deposed Dr. Warner on October 4th, she asserted that she had not formed any opinion. And then they're rehashing what they said in their statement of facts, which is something we've already covered at length. They say that the court allowed the state to proffer the opinion which it sought to elicit. Dr. Warner explained that neither battered spouse syndrome or PTSD was related to the instant offense or incident based on Boone's version of the events to her. The court recognized that Dr. Warner was not asked about this during her deposition. Again, it really is splitting hairs, but you do tell experts on deposition, don't offer more information. Like, just answer what was asked. You tell any witness that. Just answer the question that was asked. Do not, same if you're like talking to insurance on the phone or whatever. Just answer what was asked. Do not add any more facts. Do not add any more information. Don't like Dr. Rick the situation. Just don't add any more. Just what you're being asked. So I get where the doctor's like, well, they asked about PTSD, but they didn't ask about this incident. But what do you think they're there for? I see both sides of it. Still, I think that it is splitting hairs. But I do think the court remedied it. What do you guys think? They say that as a remedy, the court allowed Boone to conduct, and when I say Boone, I mean through her lawyers, but allowed Boone to conduct a deposition of Dr. Warner with regard to the proffered opinion, and Boone's attorneys did so. After the in-court deposition, the court found that it would not strike the expert as, quote, that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. Oh, so the court did discuss striking it. Okay. Fair. For those of you that are having chat issues, this has been ongoing for now, like it feels like months. Try refreshing. Hopefully it fixes it. The court found that specific areas for which the opinions were being offered were not inquired into, so the court permitted the in-court deposition in an abundance of caution. They say that Boone argues that Dr. Warner crucially changed her opinion. I don't think that's true either. Crucially changed her opinion. I think it was parsed. Crucially changed her opinion when she testified that Appellant did not give her information to diagnose her with PTSD, but indicated during her deposition that she did not have any opinion on Appellant's diagnosis. Boone asserts that the court recognized the substantial change in the testimony from the deposition. That's not what the court did. They go on to say, however, this was not the change that the court was talking about when it found that there was a discovery violation. The discovery violation Richardson hearing was held on the proffered testimony, which was Dr. Warner's opinion that any PTSD diagnosis was irrelevant because of Boone's version of events. That was new. Even if Boone has PTSD, it doesn't apply here because she did not say that her behavior was in some way triggered, if that makes sense. Trigg said, so Sarah found an appellate lawyer. The court appointed her one. That one stuck. So Boone has the last appellate lawyer that couldn't get out of it. The court recognized that the information was not elicited in the deposition and in an abundance of caution allowed the defense to conduct an in-court deposition on the issue. Additionally, when the court asked whether defense counsel wanted to strike, the court brought it up. Additionally, when the court asked whether defense counsel wanted to strike Dr. Warner's testimony about not having sufficient information to diagnose Boone with PTSD, defense counsel declined a curative instruction or to have the testimony stricken. So the defense didn't ask, the court was like, hey, boo-boo, what do you want to do? And they're like, quote, on that issue, we'll address it on cross-examination. Okay, so he said no. And when the state attempted to have the testimony stricken as non-responsive, defense counsel objected. I forgot that even happened. Thus, the argument that Dr. Warner's testimony prejudiced appellant is waived and or invited error. And then they're quoting Morgan v. State, noting that under the invited error doctrine, a party may not make or invite error at trial and then take advantage of the error on appeal. So no takesies v. backsies on this one. The court said, do you want it stricken? They said no. And then at some point, they elicited other information. The state said, can you strike that? And the defense said, nah, it's cool. We'll leave it. The conclusion on that section is that the court did not abuse its discretion nor commit fundamental error in creating a remedy, and there is no relief that defense is entitled to. So the state went through, this isn't properly preserved on appeal, and even if they take it up, here are the arguments as to why it should fail. They go on to talk now about the jury instructions, that the trial court did not abuse its discretion by instructing the jury on the initial aggressor exception to self-defense. In her third point on appeal, Boone argues that erroneous jury instructions were provided on the initial aggressor exception to the self-defense rule, and the state respectfully disagrees. They say the trial court has wide discretion on instructing the jury, and the trial court's decisions regarding jury instructions are reviewed with a presumption of correctness on appeal. Listen to that language. Presumption of correctness. So the framing on appeal is the trial court was right. Move us away from the trial court was right. We start with the trial court was right. The decision will not be reserved or reversed absent prejudicial error, a miscarriage of justice, or the instruction was calculated to confuse or mislead the jury. That's a big hurdle. They say justifiable use of force is not available to a person who initially provokes the use or threatened use of force against herself unless A, such force or threat of force is so great that the person reasonably believes that she is in imminent danger of death or great bodily harm, and that she has exhausted every reasonable means to escape such danger other than the use of force, which is likely to cause death or great bodily harm to the assailant, or B, in good faith, the person withdraws from physical contact with the assailant and clearly indicates that she desires to withdraw and terminate use of force, but the assailant continues or resumes the use or threatened use of force, and that's coming from the Florida statutes. So these are the circumstances when you are looking at initial aggressor. And again, this is a pretty clear example of, could Sarah have left the apartment? Could she have called 911? Could she have sat on the couch, kept an eye on the suitcase, and called 911, ensuring that George could not get out and the police could come because she was in fear? Yes, there were lots of options available to her here. They are saying the initial use of force is her zipping him in. Here they say the trial court did not abuse its discretion by instructing the jury on the initial aggressor exception to the justifiable use of force defense, although defense counsel objected to the initial aggressor instruction because Boone testified that she did not do anything until after the victim threatened her. The state disputed this interpretation of events. Your Honor, she said this. We don't agree. Now the jury has to decide. They say, thus, it's an issue for the jury. Boone argues that the trial court ultimately agreed to the state's request to include the initial aggressor jury instruction, which negates the right to self-defense if the appellant was committing a forcible felony. It doesn't, though. It sets up options. It doesn't negate the use of self-defense. Because if you're the initial aggressor and then you try to stop it and or get away, and then the person pursues you, then there might be an option to use self-defense, and it might be justifiable. It does not completely negate self-defense. And the state says, this argument, however, misplaces the facts. What a kind way to say it. Misplaces the facts. Your Honor, they have set them in the wrong order. It is not what is happening. The court found that pursuant to Martinez, the forcible felony instruction could not be read unless the defendant was charged with an independent forcible felony. Thus, the court denied the state's request to read the forcible felony instruction. The court never mentioned aggravated assault in instructing the jury. Appellant argues that contrary to Martinez, the court, quote, allowed the instruction modifying it to read, however, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke, ellipses in original. However, Martinez deals with the forcible felony instruction pursuant to section 776.041 sub 1. They say that the trial court did not abuse its discretion in directing the trial court did not abuse its discretion in instructing the jury on the initial aggressor instruction. Appellant is entitled to no relief. They're two different things. They're not saying that she was involved in a forcible felony. They're saying that she used force to provoke. And what was the force? Zipping him into the suitcase, then leaving him in the suitcase. And then I think the baseball bat to his hands. All right, we're almost done. Point 4, page 37. Look at us. Moving right along. The trial court did not abuse its discretion in allowing Dr. Werner to testify about her opinion. In the 4th point on appeal, Boone argues that the trial court improperly allowed the admission of the state's expert opinion on the ultimate fact. The state respectfully disagrees. The trial court has wide discretion in determining the admissibility of evidence, and absence and abuse of discretion, the trial court's ruling on evidentiary matters will not be overturned. All evidence is admissible except as provided by law. They're citing Florida statutes. Testimony in the form of an opinion or inference is not objectionable simply because it includes an ultimate issue to be decided by the trier of fact. An opinion on a person's mental status, even if it goes to the ultimate issue in the case, is permissible. And then they are talking about a different case, Dinkins, saying that the Dinkins case allowed an opinion. The defendant asserted that the opinions were inadmissible because they applied a legal standard to a set of facts. The appellate court in that case held that the opinions were not legal conclusions and did not opine on the defendant's guilt or innocence. And so getting to this, they're saying the jury had the power to accept or reject the opinions in the previous case, and that here the trial court did not abuse its discretion in allowing Dr. Werner to offer her opinion. Dr. Werner testified that any diagnosis of battered spouse syndrome or PTSD was not related to the instant offense based on the version of events that Boone presented to the doctor. When asked what part of her statement demonstrated this, Dr. Werner answered, quote, "The whole part where she's describing the part about playing hide and seek, that they were having a good time, that they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of that isn't consistent with her having a feeling that she's at imminent risk or imminent fear that there was an imminent risk of harm. Dr. Werner did not state that appellant was not facing an imminent risk, only that the description that Boone provided to her was not consistent with her feeling that she was facing an imminent risk. Also, I think that's something that the jury can appreciate, right? That the way Boone talked about this event was not Boone talking about an event where she was in fear or terrified. Then they go on to talk about a case cited by Boone, Schneer, Schneer versus Allstate. That case, they say, noted that a witness could not express a conclusion when the opinion, quote, only tells the jury how to decide the case and does not help the jury to determine what occurred. Here, they say, Dr. Werner's testimony did not tell the jury how to decide the case. Although the testimony went to one of the ultimate issues in the case, whether Boone was justified in her use of force, it was not a legal conclusion as it did not opine on Boone's guilt or innocence. Just because the opinion went to an ultimate issue to be decided by the trier of fact does not make it inadmissible. Yeah, the jury could disagree with the doctor. The jury can disagree with an expert. The jury can agree with one expert over another. And this expert said, yeah, this doesn't follow to me. So even if Sarah Boone has PTSD, which she may, this expert was like, right, she may, but This fax, as she told me what happened, isn't giving that she is terrified, that she is acting out of fear caused by George's actions or her PTSD or a combination of the both. Ray Specs in the chat says, that's my opinion. It is a perfect place for that's my opinion. Yeah.
That's my opinion!
Right. And Boone relayed what happened in a way that didn't seem to indicate that she thought she was in danger. Boone's telling of events indicated to me, after writing or reading all of this and watching the trial, that she was pissed and vengeful and was like, you know what? You're going to sit there and listen. Not I'm afraid of you, but now you're going to hear me. Now you're going to suffer the way I suffered. It was vengeance, not fear. And it came across very clearly that way to me. And the state didn't even go there on a first. The state was like, okay, fine, not intentional. Sure, not intentional. Here's a second. You didn't intend for him to die. You didn't intend for him to get out either. And then he died. That was a reasonable consequence when he said he can't breathe. It was foreseeable that he could die. So here you go. And then the videos on the phone make it so much worse. So they say that the trial court did not abuse its discretion in overruling the defense objection to the testimony. Appellant is entitled to no relief. Conclusion based on the arguments and authorities. The state asked the court to affirm the judgment and the sentence. So at the end of the day, what are they asking for? Don't overturn it. No new trial needed. We done. All right. So where are we at? And then we'll answer some questions. So where are we at the end of the state's 40-plus page response to Sarah Boone's appeal? Well, the state has said to the Court of Appeals, hey, on some of these issues, they're not well preserved. The rest of these issues, she's not entitled to relief. None of the things that they're complaining of entitle Sarah Boone to her trial being overturned or her sentence being vacated or any of the above. The trial should stand, no relief should be offered, and all of this appeal should just be denied. So what happens next? Well, Sarah Boone has the opportunity to reply. Then the court will decide if there's going to be oral argument on appeal. I would be surprised if they decided that. I'd be really surprised if they decided that they needed oral argument on this. I don't think that they will. And if they decide that they don't need oral argument on it, then the Court of Appeal will decide on the papers and the appellate record. And that will happen at some time. Does this appeal seem strong to me? No. Did the state's response make a bit more sense of what the defense was trying to argue, what Sarah Boone was trying to argue in her appeal? Yes. Also, the facts are just not on Sarah Boone's side on this. They are trying to make fetch happen, but it is not there. It is not helpful when the facts are misrepresented in the defense's appeals brief because it gives the other side, in this case, the state, too much room to say, oh, but they're misrepresenting the facts. Appeals are stronger when, A, you can represent the facts and then argue the law, but if the facts aren't on your side, you're going to have to present the facts as they are and then argue the law. But if the facts are on your side, start there. If the law is on your side, start there. If the facts and the law are on your side, well, you probably have a pretty good appeal. But if neither the facts nor the law are on your side, well, then we're getting back to bang the table. But Sarah Boone's appeal didn't even do that very well. There was no rousing banging of the table. They misrepresented the facts and then tried to argue the law based on the facts as they were skewed, which is frustrating to see because we watched the trial and then we're looking at those going, it's not really what happened. And if some of those issues weren't reserved for appeal, then, well, it's not gonna help because if they're not well preserved, then you're gonna see the appellate court say these aren't well preserved. But what often we will see with the Court of Appeal is say these weren't preserved for appeal, but even if they were, we would deny it. You will often get them just answering that question if they can, so that you don't end up, this is why, so that you don't end up with a then appeal on IAC. Because if it's like, oh, these issues weren't reserved for appeal, then you can see the next appeal would be ineffective assistance of counsel. Well, these weren't preserved, so I didn't get my right to counsel, so I had ineffective assistance of counsel. And then you get the next appeal. So I would not be surprised if even where the state's arguing that the issue is not well preserved, that we will see the Court of Appeal either agreeing or disagreeing that it was well preserved and then answering the question anyway, because it seems like a pretty easy question to answer. I do not think this appeal is going to go in Sarah Boone's favor. There should not be anything left for her to appeal after this. Will that necessarily stop her from appealing? I don't know. But if her appeal is denied and there are no grounds left, I do not see the state paying for her attorney to file another appeal. I don't think this is the type of appeal that's ripe to go up to a higher court, where if it's denied, they'll want to appeal it to the state Supreme Court. I don't even see the state Supreme Court of Florida taking this up, but we'll have to see what the ruling is. We've been talking about appeals a bit lately with the pending appeal in the Richens case. We've talked a bit about the Sharilla appeal. I talked about that on the podcast, not this week, but last week, because when it comes to appeals, there are only a few options after your conviction. And this is her main option for appeal. If she's going to try to appeal whatever the court does here, if she doesn't get a new trial, which I think is very unlikely, she can try to appeal it to a higher court, and a higher court can say no. The Court of Appeals can't. The Court of Appeals generally on your direct appeal can't say, nah, we're not listening to you. But the Supreme Court can say, there's no issue here that we need to take up. We're not reviewing this. They can choose to do that. And then you can ask for reconsideration. So we'll see. Cleopatra said, how can Sarah afford an attorney? This is appointed by the state. So the state pays. This is a paneled attorney that the state has appointed. And I'm sure she's not thrilled with it. But I did check the docket to see if Sarah Boone has sent any of her own letters to either the Court of Appeal or to the trial court, and there aren't any at the moment. So maybe that's a good thing. I can understand where Sarah would be frustrated that this has taken so long, but they did go through like 4 or 5 appellate attorneys before this brief was filed. So there's that. So I don't see this appeal going very well for Sarah Boone. That doesn't surprise me. I think the state was fairly restrained in their trial of this case. I do not think they overreached by going for a first-degree murder when they could go for a second. And I think a lot of the damage done in the Sarah Boone case was by Sarah Boone. I think the rebuttal case was devastating for her, and that wouldn't have come in had she not pursued an affirmative self-defense. It just wouldn't have. And so with that, I'll keep you posted when she replies. It's going to take months before we see an order on this. And I expect the order is going to be like, yeah, no, we're not doing that. So I'll keep you posted. So with that, we've covered the state's response. It was much more cogent than the defense's filing. And I agree with them. There's nothing here that's just glaring on appeal where it's like, that might be a problem. I don't think any of this is going to be a problem. I'm curious to see what Sarah Boone does. Might she then try to do an IAC appeal? Maybe, but I don't think that would be very effective. I'm surprised that they didn't bring up the timing in their appeal, because if you allow me a moment, let me see if I can find this. When the notice of appeal was filed by Attorney Owens, and it was like the notice for new trial and notice for appeal, he had a number of points that he brought up, and I'm surprised that appellate counsel didn't lean into those points. They brought up, Owens brought up the disruption in the court on their motion for new trial. They brought up not having enough time. I'm just going to pull it up real quick so we can take a look at it on that motion for new trial. I really am surprised that some of these things appellate counsel didn't choose to follow up on. I thought we would generally see some of those in the appeal, but we didn't. So this is just looking at the initial filing to preserve the motion for new trial. And these are the points the defendant asserted then on the motion for new trial. That one, the court erred in ruling that the defendant was not entitled to court-appointed counsel. Right. Did the court err in continuing to not give her counsel, and then they lost time, and then when new counsel was finally appointed, they didn't get any more time for the preparation of trial because she the counsel parachuted into this, and the court's like, no, I thought that would be an issue that would have come up because, hey, Your Honor, she was deprived of a full and fair defense because her counsel didn't get enough time. It's room to argue. It at least gives you something to work with because she's entitled to a defense. And arguing that she was deprived her defense, I mean, the argument on the other side is you did that to yourself, but at least it's grounds to argue. It's way better than the opening statement argument. Oh, that's a great point, Beginner Crafter said. They did get like an extra week because of the hurricane. True, but I still think there's room to say, hey, we didn't get enough. But yes, they did get more time because of the hurricane. 2, the court erred in denying undersigned counsel's multiple motions for continuance. Those two kind of go hand in hand. 3, the court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in the court in the presence of the jury prior to deliberations. I don't think it's a strong argument. I think it's a better argument than we couldn't use exhibits in opening. And then 4, the trial court failed to disallow the opinion testimony of the state's rebuttal witness expert, Dr. Tanya Warner. We did see that argued here on appeal. And then 5, was that 4? And then 5, the state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Yeah, that's a dumb argument. I think that they shouldn't have pursued that. But they pursued one of 4, and I do think they had some room to pursue these. But again, the appellate court has room to, or the appellate attorney gets to decide their strategy. I'm just still surprised that they didn't pursue some of the failure to grant a continuance and failure to allow for more time. It doesn't mean we won't see Boone try to revive those arguments down the road. We'll see. I guess we'll just have to wait and see what happens. A lot of you are saying that Boone's been very busy in the family court. We haven't looked at the family court case. But if it's not dealing with custody, I may reconsider, but we'll see. I may take a look at it and reconsider whether it ties into this, but we'll see. I will consider. As it goes to custody, no, but she's been sentenced to life in prison, so that's not really an issue, but I may reconsider. We'll see. Because I know she's been busy in the family court, but we'll see. If we have time to get to it. I mean, Massachusetts has kept us so freaking busy. However, it is nice occasionally to not be doing all of the mass things, and the state probably won't respond, or the defense won't respond for another, 30, 60 days. And we're not going to hear from Bloodworth again until September. So we've got a little bit, we've got some gaps in here. We'll see. There's some other cases I'm keeping an eye on. But we'll see if I will take a look. Lawnards, I will take a look. I'm not telling you I necessarily covered. I will take a look and see if there is anything in that might tie into the appeal here. So we'll see. But if it's just Boone being a circus, we're not going to just cover Boone being a circus, even though that might be the case. But we also have some stuff to cover. We have some stuff to cover in the Richens case still, because a lot came up about the sidebars in Richens. We have some other sidebars to get to. So we have much. We have much to cover. Let's get to questions. Newham 23 said the math stuff is so frustrating. It is. Some of you said fascinating. Some of you said frustrating. There is so much of it. Like there is so much of it. There is so much of it. Truly. Janet True said, do you think the higher courts ever go look at the video of the trial? Not unless it's submitted on the record. They stick to the record that's given to them. And most of the time, the record that's given to them is just transcribed. So, no. If there's something that's relevant that's given to them, then they would. But no, most of the time, just transcripts. So they live on reviewing what was done in a vacuum. So no, they don't go review the video again unless it's submitted. And we do have Murdacity. Merdacity's not back in court for a minute. Murdacity will be back in court next month, I believe. I did check the docket on that. There are some motions that are filed. However, they are not filed in a way that they are easy to get. And so I have not seen the latest motion that was filed in the Murdaugh case. South Carolina is just not all jurisdictions are easy. And I think we probably won't have a lot of the pretrial filings until we get closer in time, but he's not back in he's not back in court till next month. And then we are waiting for his opposition. We just covered the Becky Hill stuff in civil. So we are waiting on that. So let's get to questions. Shall we? We should. It's time. You've got questions. I've got questions. We have thank yous. We have chats to be had. So let's chat. Where did I put our let's chat? I need to rearrange things, but that's on me. Let's chat. A lot of you have asked me about cases that I have not heard of. I apologize if I have not heard of it. We have a very fulsome docket at the moment, but our mods do keep a note of the cases you guys are asking about in chat. Some of them I just have not heard of and have not had a chance to look at. I do not foresee myself bringing in anything brand new until mid next month, because there is just so much else going on and we have lots to catch up on. And my schedule is going to be a bit inconsistent because, well, we have all of the family things happening, which, as I said at the beginning of this, it's just going to be that kind of a summer. So it's going to be that kind of a summer. I am not going to get all emo about it again. CEG last stream. I got all emo about it then. I'm not going to get all emo about it now. I am going to get to questions, and then we are going to take a break about something that I have been loving from Blue Coats. I know we're going to take a minute to look at drum corps, not the Cavaliers. Shocking. I know. Victoria, this is a great question. Victoria in the chat said, can she ever take back her plea deal? No. Why can't she tell her lawyers she misunderstood and didn't want to take the stand? Nope. No takesies v backsies. No takesies v backsies. Also, I don't think it's true. I truly think, from everything we have seen from Sarah Boone, that she believed that a jury would see it her way. And I think she still believes in her soul, I think she still has convinced herself that the only reason she was convicted is because everything is corrupt. Everything's corrupted against her. The system hates women, that she is a victim, that the court was against her, et cetera, et cetera, et cetera. Just et cetera, et cetera, et cetera. So I think that she believed that the jury would side with her. And I don't think she can see objectively the things that we saw on the body cam and the things that we saw on her videos of her abusing George. I do not think she sees that. She sees that as her being a victim. She does not see that as her being an abuser. People from outside of that lens disagree. And which is why she couldn't take a plea deal, because she just can't see it. And she just can't step back and see it. Noam said, are the Boston Crusaders part of DCI? Yes. They are a world-class DCI group doing music plus like Cirque du Soleil. It is much. They've got some really, really hard drill in their show this year. And I was watching it. I'm like, how are they doing that? How are they still blowing their instruments and doing that? There is some great drill this year across the board. There is some great drill, but there is some particular drill that Boston is doing that requires so much muscle control and ab control to do that and still play an instrument. Blows my mind. It's so good. So if you have not gone and seen the Boston Crusaders show Blurred Lines, I'm sure you will find it on the internet, called something like Not Actually the Boston Crusaders Blurred Lines 2026, or Totally Not BAC 2026, or something like that. So I think you will see it. So let's see. Apparently there was weather that has prevented Boston from making it to a show tonight. That's unfortunate. Weather's tough every year. Weather's been tough this year. There's a show in Middle Tennessee on Friday. I hope that the spicy weather holds off so that they can do that show, because there are some Cavaliers are not in Tennessee, much to my dismay and displeasure, but it gives me an opportunity to see some shows that I haven't seen in person yet. And I'm excited about that, to like just sit and be a fan. I really enjoyed that this weekend. I got to, and I will share some of this on social. I have so much stuff I need to share with you guys. But then was driving more than I anticipated, and then didn't get to put it up on social, but I have some stuff to share from behind the scenes. So I got to be on the field in San Antonio, which was lovely, but also got to sit in the stands and just be an enthusiastic fan in Dallas, and sat next to also an enthusiastic fan. Had so much fun sitting with them during this. It was me and Chris, who traveled with me, and it was just so lovely. It was lovely to just sit and chat with a fellow nerd who just loved seeing what was being on the field and was genuinely just stoked to watch good music. It was so much fun. I love the enthusiasm, and I love being around people who are just like, I'm cheering for my favorite corps, of course, but I'm geeked when people do cool shit. And I love that. I love the enthusiasm. Love, love, love. So I am very enthusiastic about what corps are putting on the field. And I'm incredibly biased in favor of my kids' corps. I'm always going to be incredibly biased, but it does not stop me from appreciating what other corps are putting on the field. That's great. And there are corps putting stuff on the field that is great. Just absolutely great. Nightshade Winter said, I hope DCI isn't in Texas. They just did the Texas tour. And the shows start pretty late. The Alamo Dome is lovely. Walking from the outside to the inside of the Alamo Dome and feeling the air coming down the tunnel was glorious. It was glorious. Dallas was outside where the air is water. And we didn't go to Houston this year. We had gone to Houston last year. I'm like, Travis, how you doing? He's like, Houston always makes me feel like I'm going to vomit. I'm like, that's the humidity. Try to stay hydrated, buddy. Like, just try to stay hydrated. But difficult. Just difficult. All right. I'm going to answer some more questions about cases. I'm going to share with you something that I'm geeked over and enjoy, and then we'll go from there. So, Mom Fia 51 said, oh dear Lord, Sarah, I know. And to all the Lawnards in the audience named Sarah, I'm so sorry. It's not you. It's not you. I will try to just be like, Boone, what are we doing? It's not you. You, Sarahs, are very lovely. Boone is exhausting. It's exhausting. all the personality traits, the circular arc, it's exhausting. And then when her attorneys also embody exhausting, it's like, okay. San, thank you for the 10 gifted memberships. I saw a lot of you gift memberships today. Thank you for the 10 gifted for the gifted memberships, for everyone who gifted memberships. Thank you so much. Felicia, thank you for the 20 gifted memberships. Welcome to all the new members. We will be doing a members only this month. When I have a date, I will let you know. For all of you asking, as I said earlier, about other cases, the mods are grabbing them. Nothing new is popping onto the docket until my kid gets moved into college in a few weeks, because there is way too much on my own docket. And I don't have the bandwidth for helpful new other than keeping up with what we've got going on is a lot, just is a lot. Jen the Lawner, said my niece told me DCI was here Dallas this weekend and I was so sad I couldn't go. We were doing college things, of course. I'm sorry for the temperatures. It's not your fault. I don't blame y'all. It was hot, and I was just wet. But also, in going to DCI, I realized that I am going to just be sweaty, that my suitcase is going to be heavier coming home because all of my clothes are everything is just sweaty. But also, you're outside in July in locations for hours and hours and hours. You're kind of just like, we're just going to be gross. Great. And everybody's just sweaty. It's fine. We're all it just is. What was funny in Dallas was watching, because the Cavaliers at times take off their jackets, and then their feature performer, Devin, who's just such a beautiful performer, has to put on a jacket during one part. And you could see him just struggling to pull the jacket on because everything was just so wet, just like struggling to pull on a jacket in the level of humidity plus sweat. And you could see, if you were watching guard, not just with Cavaliers, but with others, you could see their flag silks like getting stuck to their skin because it's just they're so sweaty and it's so humid. Everything's just sticking to to them, which is actually really, really difficult. You're like, oh no, that's the worst feeling. So they have definitely been pushing through it, but also they practice so much and they rep so much, they know how to deal with it. And they're used to dealing with it, but it's kind of funny. Chloe said, absolutely love the pics of you and the Cavaliers. It was really fun. And the Cavaliers organization has been incredibly welcoming, which is also lovely because I'm just, I'm an enthusiast and I love it. Even though some of them are like, sometimes on stream you call it banned. I'm like, yes, because we are dealing with a audience that is new to DCI. So we are trying to explain and then amplify, because at the beginning it's marching band, but it's drum and bugle corps. It's the major leagues of marching band. It is band on a next level. But at the core, if you're like, but what is it? It is bands performing on a football field. So that's what we do. It's just like when we break down the law, it's what we do. Let's see. Nightshade Winter said, this is a great question. EDB, do appellate courts do any outside research, or do they take what both sides say at face value? This is not just appellate courts. Courts do not do outside research. Courts are reliant on what the attorneys give them. It is an adversarial process where the attorneys need to provide to the court the information they're using and the arguments they're making. The outside research or the research that a court can do is looking up the law. So when the motion from the state is citing a bunch of case law, I'm going to pull up the beginning of it. When they are citing a bunch of case law, the court could go read all these cases. So the court can go read the cases that are relied on. The court can do legal research, but the court can't go do outside research and look at Sarah Boone's family law case or something like that. The role of the court is to see what's presented to them, the arguments presented to them, and then to look at the law. So yes, they can do legal research. They can read and interpret the cases and the statutes, but they can't do outside research and fact-based research. So that is part of it. So hopefully that makes sense on the research that courts can do. And there's times it's frustrating when the court refuses. I hit this wall of frustration recently in Reed when the court refuses to take in outside information or more information. Right. It gets frustrating. Let's see. The Cozy Treehouse at EDB loved the behind the scenes from DCI. I was fascinated by the scale of everything. It is impressive. The amount of everything that goes into it. And it's kind of beautiful chaos at like San Antonio because all the cores are in one place and the parking lots are just so full of core members and buses and loading in and loading out and all of the things. It's just a wonderful chaos. I'm also glad that I get to be there as an observer and I'm not trying to wrangle marchers from one place to the other. I also think that we probably walked like 9 miles of walking on San Antonio Day. It was so much walking. There are more stories. We will save some of them for members only just to not bore you with San Antonio Day, but y'all, if it could go wrong, it did. And it did. LJ Peach said, can we just say Massachusetts hates out-of-state lawyers? That's not specific to Massachusetts. That's not specific to Massachusetts. We saw that. We've seen this across jurisdictions. This is not specific. We saw this in, the Rust cases are a good example where you had just literally Carrie Morrissey being like, Your Honor, these big city New York lawyers, New York City. It happens in every single jurisdiction. Every single jurisdiction. So it's not specific. Tori with a T said, Emily, this is random. We love random. The ADHD thrives on random. Sometimes lawyers call the judge Your Honor. Sometimes they call them judge. Is one of them less respectful than the other? I think you really have to be specific when you are looking at a given jurisdiction and interaction. This can also be regionally specific. There are times when either can be disrespectful, depending on what else the lawyer says, or less respectful. But there are regional differences in the way people refer to the court. One of my favorite moments was, and this is why it's on the soundboard, let me find our not today judge, because it was so funny when the judge was asking questions and the prosecutor just cut the court off and was like, not today, judge. Like, judge, we're not doing this. What we're not doing, Your Honor, what we're not doing is this.
Not today, judge.
I thought it was so funny, but it really just depends. It can also depend on the lawyer. And if we don't see lawyers over multiple cases like you would if you were working with them, it's hard to know if that's always what the lawyer means. But when you're working with a lawyer regularly, there's times where you can be in court and the lawyer starts arguing and you're like, oh, they're big mad because their languaging has changed and you can just tell. But some of those things are harder to look at in a vacuum. And sometimes we're just in a vacuum a little bit. So it really depends on context. So I don't read into it too much because I don't always have a baseline for the lawyers. The more that we see the lawyers, the easier it is. So it depends, but it really can be more specific. Which case is not today? Not today judges from early days Koberger with Judge, because Judge, there were days Judge was just like there for the vibes, it seemed. And I don't mean that in a negative way. It's like Judge was there for the like intellectual exploration. And the prosecution was like, can we stop? Can we know? And the judge was like, let's explore this. Like he was going to deny the thing anyway, but he wanted to have the stimulating conversation. He was just amused by the back and forth. And there are some judges that just love the back and forth. And even if they're going to rule against an attorney at the end of the day, they want to have that verbal back and forth, and they want to explore the ideas, and they want to be like, walk with me through this thought process. I just really am excited. Some judges don't have the time, and Judge really loved like a conversational rabbit hole. And the prosecution was like, can we not sidetrack? Not today, Judge, not today. But you could tell that Judge enjoyed the back and forth. The problem is in such a extensive case, there just isn't time and sometimes bandwidth for those rabbit holes. And so the defense hadn't brought something up, and then it had kind of been a tangent. And then Prosecutor Santa was like, no, we're not side questing. Rein it in. Rein it in. It was funny. I loved it. I was amused. I was greatly amused. Donna said, hope Dr. B's back is feeling better. It is feeling better. It is a process. It is not herniated. It is just pissed off. And it's just going to take some time, but it is definitely feeling better, which is, I'm glad, because I was able to travel, because I wouldn't leave. If Dr. B was incapacitated, I'm not leaving him here like Dr. B and Griffin. Good luck, everybody. I'll be back. But it's going to take some time, but he's got some time. So, which is fantastic. LSU Diva said, my freshman is headed to watch DCI in MS. Is Mississippi? Missouri. Is Missouri MI? I'm not sure which one MS is. I know there are like 3 shows tonight. I hope it is delightful. I hope it is wonderful. I promised you we would talk about Blue Coats for a moment. For those of you that are new to DCI, if you ever go to a show, they're not booing the Blue Coats. They're never booing. MS is Mississippi. Thank you. MO is Missouri. Thank you. MI is Michigan. Right. The moments where you can tell that you grew up in California. I've got MA down. Thanks, chat. Enjoy Mississippi. I hope it's amazing. Cat Mom, don't worry. I'm going to be adding more DCI behind the scenes stuff to Instagram later today. So do not worry. There will be more. And we can talk about it another day. Janie said, Emily, one of my dance friends, has a son in the Blue Stars in DCI. She was telling me how much she loves the Cavaliers show this year. I love hearing it. I also love the Cavaliers show this year. The Cavaliers and the Blue Stars have been like locked in a points battle this year. There's a lot of points battles going on. There's everybody's kind of bunched up in the like middle top there. It's going to be close, I think, between now and running into finals, though. Blue Coats scoring has just been like just off the chart. Okay, let me grab what I was thinking of real quick, because I promised you I would show you how excited I am about the Blue Coats encore. Now, every corps has encore songs that they do. The encore songs can change. They are different from the corps song. Corps have a ton of traditions. I have shared some of the Cavaliers traditions because I have more of a front row seat to some of the Cavaliers traditions, but corps all have their different traditions. I think it's incredibly cool. It definitely makes them feel like a group, and that includes encore songs. And the corps will do encore songs sometimes after their home shows, sometimes after finals, sometimes in the lot. Let's see. I've got a little clip of the Cavaliers, and they change their encore songs year over year. Let's see if we have their... I saw their encore from their home show, which was, let's see. That's not it. Let's see if I can find their encore song, not their home show song, real quick. But did I cue it up? No, because we're going to... Emily, I thought we were talking about Blue Coats. We are absolutely. Let's see. I'm just trying to find it because I found it and I don't know where it went, but that also might be because it might be on a different, It might be not on YouTube. So apologies, chat. I will find it, and we will get to the other thing I'm talking about once we find it, and I close the loop in my brain. Because it's got to be in here somewhere. That is from too many years ago. That is from too many years ago. That is from too many years ago. Nope. Cannot find it. I will look one other place. Let me see if I can find Blue Coats, and then we'll come back to it. But Emily, did you grab these? No, I grabbed court documents. We'll grab the Blue Coats, though, because their encore is so much freaking fun. I absolutely love it. And, well, Emily, are we just going to lean into being responsible? Yes. We are responsible, law nerds. It's summertime. We're just going to be responsible with our use of music, because all of us, after talking about appeals and murder, we could use a music break. It's a swoop, if you will. And I love this arrangement. I think it is so much fun. For the 4 of you that know what's happening, be excited. For the rest of you that are just like, I have no idea what to expect from this arrangement, be excited. Be excited, because I am. All right. Let's take a look at the 2026 encore from Blue Coats that EDB absolutely loves. Absolutely loves. I don't know if there's a better encore happening this year. I don't know if there is. There might not be. You guys can tell me in the comments if you think anybody's doing a better encore, but my personal music tastes play heavy into how much I love this, because I love it. So this is after their home show performance. Yep. I love how hyped this is. I love it so much. Look at this. Look at the bottom. I'm kind of in the way. Look how hyped the rest of the core is. Look how hyped the rest of the core is at the bottom. Look at that. Look at how excited they are. Look at the jumping around. I love how excited the core is. I also love that they're just chilling on props up here, swinging their legs. Come on with the mashup. Come on with the chop suey, where the hell is my husband mashup. Come on. It's so good. I love it so much. It's just so much fun. It's so much fun. I love the way they tied it in. I just love it. I just love it. I'm backing that up a little bit because, baby, where the hell is my husband? I love it so much. Whoever arranged this, 10 out of fucking 10. Because look at how hype your core is. Look at how excited they are. Oh, just such a great mashup. Blue Rose in the chat. I see the winky face. I'm not a marching member. It's not mine to discuss. And yes, does it get louder? Yes. Are they dancing on the field? Yes. Are they absolutely having the best? Yes. Yep. Are they having the best time? Yep. Does it get louder? Yes. Is that me doing it? No. It's them. I love that the whole core is just jumping around, because how can you not? Come on, that's hype. Let's go. Look at how excited the trombones are. Come on. It's such a good mashup. I don't think I've ever seen trombone players rock out quite like that. The arrangement of this is so fucking good. And the trombones in the front are just like boogieing when they're not playing. So much fun. Their encore song is so much fun. Come on. Come on. Come on. So much fun. You guys, a lot of you are asking, Emily, where's the percussion line? The percussion line is not in that encore, though there is a full fucking drum kit. They are not the only corps that has a full drum kit, but there is a full drum kit on the field. So you heard the drum kit. The arrangement of that piece of music is so freaking good. It's so good. I love it. It's so fun. I love corps doing their encores. Their encore for the last couple of years has absolutely slapped. But the Chop Suey, Where the Hell is My Husband mashup? Look, whoever wrote that for Blue Coats, God, it's good. That arrangement is so good. No notes. The way that the songs weave together, so freaking good. And if Blue Coats continue scoring the way they're scoring and win, I want to see this live. I want to see their encore live. I want to see their encore live. I really do. I love the Cavaliers encores. I am very hype when they play Rainbow. I think their arrangement of it this year is beautiful. I love their core song. I love all of them jumping around and singing their core song at the top of their lungs. But also this, come on. It's so freaking good. It's so good. It's so good. I love it. I love it. And then the trombones are just like, there is so much trombone happening in DCI this year. I love it. I love it. It's not just Boston playing trombones with like their feet. I love it so much. So much trombone happening this year. It's good. It's good stuff. It makes me so happy. So let me see if I can find, I know I said I was looking for something else. Let me see if I can find a little bit. Maybe it's on Instagram. Because there is a little bit of Cavaliers encore song, but I love it. I love it so much. Let's see. Because their Rainbow is easy to find. I don't know why I can't find it. However, we can always save it for another day. Some of you were saying playing with their feet. Last year in Boom, there was a bit where the trombone section for Boston Crusaders were sitting down and using their feet on the slide. It was fantastic. Let's see if we can find it this way. There we go. We found it. Where is it? That is, all right. Give me 1 sec. We'll pull this up because I was on the wrong platform. Can we just pull up the video? Why can't we pull up the video? Hold on, there we go. All right. This is a recording of the Cavaliers. No, where did you go? Okay, there we go. This is not on YouTube, but I'm gonna grab it. Anyway, it will be fine. See if we can embiggen this and turn on the volume So this is a fan cam recording of the Cavaliers doing their encore this year. Yes, they change their encores every year. This is from their home show performance. I think it's a lot of fun. However, the Chop Suey mashup is just a 10 out of 10. I turn that down a little bit. It's just fun. So, drumline's down here in the red. Guard is down here on the field as well. Staff's down on the field. They just have a really good time. A really good time performing their encore. It's a great song. It's hype in a different way. One of the things I love about the encores is how much fun they have. It's one of the things that just warms your heart. Because at the end of the day, music should be joyful, I think. And I love that they get to bring some joy into their performances with their core outside of just their show. I love it so much. I had to turn it down or it would just wreck everybody. Look, everybody has time for some fun. Hence the sideline dances. Drum kit. Full drum kit. Full drum kit. Emily, are the Mellows having fun? The Mellows are always having fun. Always having fun. They're always having a good time. Of course they are. So that is their, let me turn off the volume on that. That is their encore song for this year. I am sure I have it saved elsewhere as well, but that is their encore song for this year. They also do their core song and they also sing their core song. They also sing Somewhere Over the Rainbow. They have their own version of it. That's for another day. But also, you guys, we talked a little bit about things that come across Emily's Instagram. Why? Because it just was it was on my mind. Let's see. Let me see if I can find it. Did I think I was going to talk about it? No. Did it happen? Yes. And now we're looking for it. So hold on. We're looking for it. Well, maybe not. But we'll find it. And then we'll finish answering questions. So let's see. All right. This cracked me up on Instagram. So we are going to take a look at it real fast because it came across my feed and then we were talking about Xzibities and then things happened. So we're going to talk about a little bit about Xzibit the rapper and his cat Thundercat, because this is the Instagram story that came across my Instagram of Xzibit talking about his cat, Thundercat, because do I love seeing somebody talk about their cats? Yes. Yes, I do. Hold on. We are going to
cats that much, but
He's like, why does everybody wants to know about my cat? Yes.
Cat has been in my life for a long time.
Everybody wants to know about your cat, Xzibit.
She's seen it all.
Yep.
And everybody's asking how I kept her alive for, this long.
20-year-old cat. She's a 20-year-old cat. She's a 20-year-old cat. That's amazing. We love it. I love it so much.
Well, first of all, I love my cat. I take care of her and I look out. So she's an older cat. She had a thyroid issue and there was a treatment that I had to get done.
As happens. So he talks about, let's see if we can zoom a little bit. He talks about
and to fix that
the food for the cat, but I wanted to show you. Let's see if I can. I wanted to show you all the things that he shares that his fans send him for his cat. I just don't know if I can do that, but we'll see if we can zoom a little bit, because I wanted to show you all what, not what Xzibit is feeding his cat, but what the fans have sent. So I'm going to let it play, but he's just like, what do you mean everybody wants to know about my cat? Yes, everybody wants to know about Thundercat. Everybody wants to know about Thundercat, which is incredible. So after he gets past talking about Thundercat's food and all of the things, we're going to get to the fan appreciation of Thundercat, because that's absolutely what I wanted to share, because it's so much fun. But he talks about the health issues. He talks about taking care of the health issues, having the vet care to take about the care of the health issues. So we will check back in just a second with all of the fan art, because the fan art is so incredible. Also, having a cat live to 20 is absolutely incredible. Albus was 17, almost 18 when she passed, and it was heartbreaking. But I felt so blessed to have a cat for so long.
People send me shit all the time,
so look at
associated with my cat. The fact that this is going crazy is beyond me. But this is the kind of shit
I love this, by the way.
I get. I got like sweaters with my cats.
That's swaggy. We love Thundercat. I love this.
Face all over it.
That's amazing.
Yes, I've worn this before.
As one should. As one should.
Make paintings of my fucking.
Okay, this is amazing. I would build an entire library around this painting of Thundercat. It's so freaking good. It's so good. Hello, Thundercat. This is incredible.
Cat.
It's incredible.
They make paintings of this shit.
It's amazing. As they should. Look at the talent.
When I say paintings, I mean multiple paintings.
Is that a Bruce Lee Thundercat? I think so. Okay.
Yo. It's no joke.
Right.
People love Thundercat. I love Thundercat. I'm glad you guys like her as much as I do. All right. So as we speak.
What's Thundercat up to? There we go. Thundercat gets to eat on the couch. First of all, don't show Fred and George.
What you got to say to the folks, Thunder?
Leave me alone, I'm eating. Anyway, Xzibit has been sharing about his cat on Instagram. Apparently the cat has cameos, so you can cameo with Xzibit and Xzibit's cat. I think it's hilarious. I love it. I love when people share just a little bit of their life, their pets, and it's hilarious. And I also love the hoodie that he's like, I wear it. 10 out of 10. Again, enthusiasm and joy, 10 out of 10. Get it, Thundercat. This cat is so well cared for, and I love people sharing their love for their pets and the genuine love for their pets of like, literally, I would do anything for this cat because I get it. I get it about my cats. I get it how people feel that way about their pets. I love seeing it, and also it's a little bit of a positive side of humanity, because we cover so much of the hard stuff, and sometimes it's really nice to just cover people being enthusiastic about music, which in the summer, it's going to be 100% Emily being enthusiastic about music and not Emily crying about some of the amazing Dave shows she's missed, because Emily's very blessed. Emily, we're talking about ourselves in the third person. I am very blessed to get to see my kid perform at the level that he is performing. Some of the set lists this year have been absolutely mind-blowingly good. And I've been like, oh, but it's okay. You know why? Because the DMB Hub app has all of those recorded and I can listen to them. And there is nothing like seeing my kid in person at a show, and occasionally him looking over as I'm recording, like them going in or out of a place. And he's just like, hi, Mom. I'm like, hi, buddy. But we did get to spend some time. On the EDB has been needing to upload things for y'all. I have lots to share. In the EDB needing to share things, I didn't realize that when I was driving because we went to Austin and I did some stuff with flow marching that I will let you know when it is out, but it is around and for DCI finals, which was really fun. We got to go to flow marching new office building headquarters. Their office building is like in a tree house. It was super cool. We got to film in their studio. It was lots of fun. Had a great time with flow, but that was in Austin. Then went to San Antonio. What I didn't plan for, DCI days are long days, especially our San Antonio day. We went from Austin to San Antonio. We went to go see their practice, helped out a little bit at practice with food truck because I can absolutely serve food to marchers. However, that does require standing outside in San Antonio in the middle of the day. It was warm, very, very warm, but we got to go see the Corps. Guard was rehearsing indoors because it was so warm, which was lovely. We were indoors for a little bit to see Guard, but we went and saw their open rehearsal for a bit, helped a bit with food, got changed, went over to the Alamo Dome. At one point, I was like, we can go out and watch them. And then we did not because we could see them through the windows. And one of the security guards is like, do you need any help? And I'm like, we're watching because we don't want to go outside. We're going to stand here and we're going to stand here and just watch through the window. I don't actually want to go outside. It's like, hey, buddy, it's so miserable outside. It's so miserable outside. So we're going to just stand here and just be like, hey, everybody. So then we got to see them a bit pre-show and go, I have stories to share for you, go under the Alamo Dome and walk out onto the field and watch from the sidelines, which was absolutely fantastic. It was lovely to get to see them do their core song underneath the overhang. It was fun watching the Cavaliers march in. And I have some video to share with you of their friends standing up above at the Alamo Dome, like yelling at them as they were marching in to perform and just shouting encouragement. It was really fun to see. We had a great time, and San Antonio got to see the Corps after they performed, before they took off on buses. We tried to find food afterwards. It was more difficult than one anticipated. I did not anticipate how difficult food after the hour of 10 p.m. on a Saturday would be, but unprepared. It was a little challenging. We finally found some food, finally got to bed very, very late. What I did not adequately anticipate is that after getting to bed incredibly late on Saturday in San Antonio, that we would be going to Dallas the next day. And in my brain, I was like, oh, that's like a 2.5. No, it's not. I was like, that's a 2.5 hour drive. No, it's not. No, it's not. No, it's not. No, it's not. I don't know why my brain thought that was a closer drive. But it's not. So I had miscalculated the length of drive. I don't know why my brain was like, it'll be fine. It's fine. It's just not exactly what I was anticipating. Sure isn't a shorter drive, but we drove from San Antonio to Dallas, had a lovely dinner, went and saw the Cavaliers, did not go to open rehearsal that day. I was like, no. Mm-mm. There was much construction. I was unaware. It was fine. You know what? We had time to shower. We had time to stop at Buc-ee's. We had time to get some good food. Time to get to the show. Got to see Travis. The show had gotten a bit rain delayed, so we actually had a little bit more time with Travis before he had to be on the bus, and it was lovely, and got to spend some good time with him. However, we went to the loveliest dinner. And I am going to complain so much for a few minutes. So bear with me. We went to the loveliest dinner at a very nice restaurant, had a lovely steak dinner. However, sat down, beautiful, beautiful seat by the window, lovely, lovely staff, glorious. We sat down and we started chatting, me and Chris, before we, go to the show, just having a lovely time. And the table next to us, almost the entire time, because eventually there was a manager who was quite helpful, because at this time, EDB was just like, I have to go to a show tonight, and this is not for mine to deal with. But the table next to us was on the phone, and I have no problem with you being on the phone in a restaurant. I'm having a conversation with the person next to me. But they were on FaceTime, full volume. FaceTime, full volume. Full volume on FaceTime. Be on the phone. Be on the phone. Get a headphone. Look, if you're dining by yourself and you're on the phone, I don't give a fuck. FaceTime at the fullest of full volume, which, again, we were at a lovely restaurant having a lovely dinner. There was no music in the background. It was not a loud restaurant. It was very much, everybody was talking kind of low because you could hear each other because the vibes were kind of a quiet, chill vibe. FaceTime at full volume. I don't give a shit where you're having dinner. FaceTime on full volume is never acceptable. I don't care where you are. FaceTime on full volume is not acceptable. This is not an emergency. FaceTime on full volume is not acceptable. And they were talking about all the types of things. And I'm like, I don't want to know. Look, Esther, I don't want to know. Also, Esther, well, you were on the phone with these dudes, clearly in a pool somewhere, because we could see your entire FaceTime. He was periodically pulling up text with other people while you were on FaceTime the whole time and talking about getting drunk and who they were taking back. And we're in the middle of the day at a steak house with a glorious menu and the best mac and cheese with like the homemade mac and cheese, the best mac and cheese. And we're drinking espresso martinis. Look, man, why are we drinking espresso martinis with steak? Am I judging you? Yeah, I'm judging that. What are we doing? Have your espresso martini afterwards with dessert. What are we doing? But also, girl, if you were the one on FaceTime with these two dudes, they were texting other people while they were talking to you. Why? Because I could see it and hear your entire conversation, your whole conversation. And then when they got off of FaceTime with Esther, Esther called back and they just put it on speaker. And then in the times that they stopped being on the phone and on speaker, they were scrolling through Instagram Reels, not TikTok, Instagram Reels on full volume. Full fucking volume Instagram Reels. So, first of all, Esther, these dudes are not it. The way my soul wanted to get up and be like, they're texting other people while they're talking to you. And at one time, our waiter came over and is like, how's dinner? I'm like, y'all are lovely. I can't do this. And the waiter's like, yeah, I've been told that I'm not allowed to handle it the way I want to handle it, and I have to wait for management. I'm like, I am 3 seconds away from grabbing that phone out of his hand and dropping it into his espresso martini, which would be rude because I'm sure the bartender made an incredible espresso martini. Also, pre-dinner, fine. After dinner, fine. But what are we doing? The way I was like, can someone just get me a pitcher of water? I'll just drop it in. The manager finally came over and the staff was just like, we're so sorry. But everyone else in the restaurant is just like, and I'm sitting here going, I might I might be willing to just be like, shut the fuck up with this. Just shut up. The two of you aren't having a conversation. You don't even have your speakerphone at the volume of a reasonable conversation. Also, what are we doing when the phone conversation about why are you here, not there is done? Why are we scrolling Instagram? Do the two of you have nothing to talk about? Clearly not. And I'm all here for scrolling Instagram reels with your friends. We just did it and be like, oh my God, have you seen this? Not while you're sitting at a restaurant. What are we doing? So I was just like, talk to the person you're sitting with. Why are you scrolling Instagram reels? Why are you texting someone else in the middle of a FaceTime conversation? What are we doing? Also, not Gen Z. Not Gen Z. Generously elder millennial. What are we doing? Speakerphone in public is a no-go. It's a no-go. Speakerphone in public is a no-go. And so Petty Emily is just like, and then I was tempted. I was going to be like, you know what? We should just start reviewing the show from last night and we should just start blasting this DCI show out of my phone in their general direction. However, there are other people in this restaurant right now, and that's not kind to them. But everyone else in the restaurant is just like, what are we doing? Also, can we have a cell phone policy where people can just be like, hey, you're welcome to step outside and be on the phone, but you can't be on speakerphone here. So the manager finally came down and was like, how is everything? I'm like, it's way too loud is how it is. It's way too loud. And unfortunately, it seems that your waitstaff, who is lovely and would have said something, is constrained by whatever decisions have been made here. And it took y'all a good 25 minutes to come and address the situation while I'm trying to enjoy my very, very lovely caviar appetizer. So could we not ruin my day and everyone else's day? Everyone else in the restaurant is sitting there like, how did it take so long? How did it take so long? Also, what do we need to talk about on speakerphone in the middle of a restaurant that is quiet? We're not at the club. And even then, listen to Lady Gaga. I'm at the club. I can't hear my phone ringing. No, we're not here. So I was like, I do not have the bandwidth to handle this without making it a fucking scene. And I was just like, but I appreciated that our server was just like, I am not allowed to deal with this situation the way I would like to. I'm like, you and I are on the same page. You and I are on the exact same page because it is so freaking rude. It's just so rude. So and then it distracts my whole conversation because now I'm just like, why is Esther on FaceTime in the pool? First of all, because clearly in the pool. Also, why are you talking to these two jokers? Because they seem fairly appalling just based on what I've heard in the conversation. And they're texting at least a name saved in their phone that seems to be a different chick while they're on FaceTime with you. So what are we doing? Also, why in the world would you put up with someone that would behave like that? Anyway, absolutely wild. Absolutely wild. So we sat down to have a very lovely dinner and I was trying to like not rage. So they finally told them to stop it. And then they quickly wrapped up their meal and left because apparently not being able to scroll Instagram reels at full volume during dinner was too much of an inconvenience for the iPad kid 40-year-olds sitting across from us. I'm sorry. You can't sit at dinner and have a conversation with the person that you're sitting with without scrolling Instagram reels? Come on. But yes, the screenagers couldn't even tolerate not being on their phones. So I'm glad that was our only run-in with these patrons. It was wild to watch. I'm like, also, what are we doing? Just put an earbud in if you need to talk to somebody in a restaurant. It's fine. Sometimes you have to chat. But you are not the only person that exists in this world. So, and I don't care what you're doing. I don't care if you're on a FaceTime. I don't care if you're trying to watch sports. Speakerphone in public is a no. Speakerphone in public is a no for me, dog. It's a no. It's a no for me. Ever. There is no reason. There is no reason. It's rude to everyone around you. So, I'm all for people getting to make their own decisions. But those decisions should never, ever be, I need to be on speakerphone in public right now. No, you don't. No, you don't. Get in your bud. Or wait till you're done eating a meal. You really need to be scrolling reels while you eat a meal? Okay. Maybe we need to have a conversation about phone addiction. However, there was one moment where another patron of the restaurant walked in and stopped where the two of them were and was like waving to the person on FaceTime. And I was like, surely this will be enough. Surely this moment will be embarrassing enough as the other patron walking in was just like, because I'm watching all this happen. And no, that wasn't it. No, that wasn't it. No, it wasn't. So, everybody, I know you guys get it. It was funny. I know y'all get it. But yeah, no speakerphone in public. No speakerphone in public in the restaurant. There was nothing that was needed. It was a completely inane conversation. They were not using their phone to try to help overcome a communication barrier. They were just being absolutely entitled and rude. Your conversation's not more important than the rest of the world. If that conversation's that important, put in an earbud or step out of the restaurant. It's literally 2 steps away. Also, there is no need to scroll Instagram Reels at a meal on full volume on speakerphone. There's no need. If you want to scroll Instagram during your meal, I don't care. Go ahead. Put in an earbud or turn off the volume. But what you're not doing is just assaulting the rest of us with the constant scrolling of Instagram Reels. They weren't even watching them all the way. Scroll, 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 scroll. Woo! So the meal was lovely. But I was also sitting here just being like, we don't have time to cause a scene. Because I cannot sit here and wait for law enforcement to get here to explain that this is justifiable rage. Because again, this is justifiable rage. But I do not have time to explain why I ripped the phone out of this human's hands. So I'm going to let them handle it. I'm like, my options are to either get up and leave, like, check please, or to let them handle it. And they took a really long time to handle it, but let them handle it because also I don't think we had sat down for like a full actual meal in a couple days because DCI days. You're just like, you have breakfast and then you're like on the go all day and you're kind of just snacking. And then it's like 1 a.m. So I was really excited for the meal, but also the noise distraction was so bad. There were, because hotel, restaurant, and everything else at that point was closed. The more casual dining options were closed. There was a table. The guy who was walking into the restaurant and was like waving on the FaceTime was sitting at a table with his family with kids. Do you know what the children were doing? While they were waiting for food, they were on their devices a little bit with no volume. And then when they got food, they were having a conversation with their family. So look, when the 5-year-old has more impulse control, it's a conversation worth having. Again, just turn the volume off. I don't give a shit. Just turn the volume off. Again, it's fine. Heather says, only exception I'm okay with is FaceTiming at the grocery store because someone is perplexed by an item on the grocery list. Fair enough. It's situational. Absolutely situational. If I saw somebody in a store on FaceTime being like, is it this one or this one? I'm not mad about it at all. It's situational. It's also brief. This was anything but that. Also, this is now a public conversation. And I don't know why whoever was on the other end of the phone was putting up with all of this. Also, if you can't even have a conversation with the person you're sitting with and the person you're having on the phone with or whatever, and you're still flipping to texting other people, I don't know why they're bothering with your attention. So it was a whole thing. It was a whole thing. Whole thing. On a slightly related note, open ear shocks are fantastic. I know, AirPods, wired internet, wired headphones, whatever. They give the table crayons at one of the restaurants I go to. It's fun. I really wish somebody had just handed them a box of crayons and been like, here, if you need to entertain yourself, it's fine. Just whatever. You wouldn't have even noticed what they were doing if the volume was off. I would not have. I wouldn't have cared what they were doing on their phone if the volume was off. Yep. Can't imagine. But I was just like, and then I was trying to like restrain myself. But it's also the volume was so high that it kind of overtook anything we were trying to have a conversation with because it kept interrupting. And the volume on the other end, because Esther was in a pool somewhere, the volume on the other end of the phone call was also quite loud because they were FaceTiming in a pool wherever they were. And there was background noise on that end too. It was so. But the show was delightful. And the meal, though the noise was much, the meal was delightful. I felt bad for our wait staff who was like, we're forced to wait for our manager. I'm like, that's great. That's great. So it was a moment. It was a moment. If I did not have to go to a show later, I might have chosen a different adventure. But also, it is not my place to get into this business. I was just like, this is their place of work. They can handle it. This is not my situation. This is not my situation. I can control myself. I can complain, which I did. I was like, hey, y'all, this wasn't a quick, 3 minutes. This has been going on at that point for 10 minutes. This is ongoing. And when there's no phone call, it's the reels and then back to the phone call. This is not acceptable. Can somebody please, I'm sure you have a phone policy. Can somebody please make it stop? Immediately make it stop. Or I'm going to have to make it stop. Please make it stop. And then just trying to enjoy. But once they were told that they had to knock it off, they very quickly wrapped up their meal and left. But also, it was an adventure. The show was lovely. The high school football stadium because Texas is basically a college football stadium, was lovely. Getting to see some of the shows was lovely. I was very happy to get to see the Blue Devils show for the first time. Really enjoyed their show. Again, got to spend some great time with T, and the meal ended up being good, though the environment was a bit loud, which was not what I was expecting from the nice. Did they terminate the call when asked by the manager? Yes. And then they stopped scrolling on the reels at full volume. And then they wrapped up and left. Because apparently that was, what they were trying to do. But again, other than the heat, which we expected, there was a little bit of a breeze by 11 p.m. So that was nice. Travel was pretty easy. So that was nice. I'm still a little tired, but that's okay. It was fun. Got to see my friends, got to see my kiddo, got to see some great shows, and we'll talk more about it on members, and we have more streams for tomorrow. Can we please talk about T's side-eye when you accidentally filmed him coming out of a show? Oh, I didn't accidentally film him. He knew I was there filming, and they were walking into their show, but the hi mom is his bit. That's his shtick. He was just like, hi mom. Don't worry, I've got more videos of him saying hi mom, but that's it. He knew I was there and knew I was filming because I've asked him, because I let him choose. And I was like, if you don't want me filming before shows or filming guard, it's totally fine with me, because their media team's filming all the time. He's like, no, I don't care. And they're filming all the time. And he's like, I don't care. But he absolutely loves the shtick of the hi, mom. Yeah. And I think it's hilarious, because I know that I'm getting all of the sass from him, which is fun. But no, he and I had a conversation before the season about what he was good with, but their media team is there filming all the time. Their media team's incredible. Their media team's absolutely incredible. But mom likes to record too. So yeah. No, I need to get him probably at finals to say hello to y'all, because it's going to be a minute before he pops in on a stream again. It is going to be a minute. Music to my soul. Emily, I'm curious if Esther is actually her name. I don't know. That's what the name she was saved under on the phone. The only reason I know that is because we could see his entire phone, because there was no discretion. Obvious at all. None. So, Lawnards, we have lots to discuss tomorrow. I will be back streaming tomorrow. It's good to see you. But also, just know that it's not you. When you're in a situation where you're like, why are people doing this? I don't know. I was just like, it's going to be fine. It's going to be fine. And you know what? Instead of just sitting there and being miserable or interceding aggressively on my own, which a younger version of me probably would have chosen, I just said, this is not acceptable. Can somebody please handle this? Thank you. That would be lovely. This is not okay. And though it took a while, they did. And that's all we can do. It's just, and it's not just me. You can see, or someone who is aware of everyone around them, you can see everyone around just being like, what are you doing? So it's not just you. And I do appreciate that our waiter had a sense of humor and was like, I would love to handle it my way. And I am told that I may not. I'm like, 10-4, I understand. Thank you for taking care of it. Because I appreciate the acknowledgement that I appreciate the acknowledgement of, yes, I would also love to just take the phone and drop it into a vat of water. Or just tell everyone to leave. So I will see you tomorrow. Lawnards, you are the best. Thank you for being here. Thank you for being a Lawnard. Don't forget that during the summer, we are going to have some inconsistencies with my traveling. Make sure you have the Lawnard app so I can keep you in the loop. And don't forget, if you don't follow me on Instagram and want to see some of the more of the behind the scenes, Instagram, at the Emily D. Baker, you can follow me there. I will be sharing that there for those of you that don't Instagram, but if you are in the Lawnard Lounge, I will also be sharing it over there. So you have it all. And with that, it is time to get going. I will see you Lawnards tomorrow. Thank you for being here. Thank you for being a Lawnard. You're the best. Let's roll the outro. Good to see you, everybody. Good to see you in chat. Thank you, Team Baker. And I will see you soon. Let's roll the outro. See you tomorrow. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnard app at lawnardapp.com. It's a free download on iOS and Android, so I can keep you in the loop.